Yes.
Adjournment request, if any, from item number 1 to 7.
May I please your lordship, item number 7, urgent for the donate.
All right. Adjournment slip.
16.3. From item number 8 to 18, adjournment request. From item number 19 to 23.
Yes, may I, my lord? My lord, with the concern of the other side, I beg to mention item 17, my lord. But in this case, we need to, I'm appearing for the higher education department, my lord.
Hmm.
We need to file affidavit, my lord. Kindly 2
Have you
weeks.
informed the other side?
Yes, my lord. 2 weeks.
As prayed for on behalf of the respondent. After obtaining consent from the council for the writ
Seven.
petition,
17.
17.
re-notify on 4 weeks. Provincial.
18.3.
Bachelor's.
Wait, please, madam. The item number 11, I'm for response number 40, I would like to withdraw the matter.
11, you want to withdraw?
Yes, madam.
You have been appointed a public
Yes,
prosecutor. Very good. What is
I
your
will-
name?
Response number 40.
What is your
I'm
name?
Desina, yes,
Miss
sir.
DC.
Desina, advocate Desina. I would like to withdraw my appearance in the matter.
No, how can you withdraw the petition?
I'm
You are
for
appearing
respon-
for respondent.
Yes, madam.
No, petitioner has to withdraw, no.
No, not the matter. I'm from my appearance in 40 and.
You want to
40.
withdraw your
from
wakalatnama.
40, yes.
All right, we will, on the day where, please wait. We'll record it when the matter is argued. Oh, you would spoil the case of the petitioner. I thought.
No, my lord, I'm in the respondent side now. 40.
All right. Appear when,
Obliged.
tell us when the matter is taken up.
Okay.
Item number 19 to 23. Item number 24 to 31, adjournment request.
May I please, your lordship? With regard to item number 28 and 29, my lord, I'm seeking some accommodation in the matter. I'm led by Mr. T.K. Misra. Senior.
We completed the hearing.
My lord.
Simply for letting Mr. Mishra know
My-
that with the new amendment, I think his grievance is over.
No, my lord. The grievance isn't over, my lord,
Isn't over.
because I'm paying the,
You want- no.
the
Well-
matter can be taken over Tuesday next, my lord, on 3rd of February. my lord.
All right. As prayed for on behalf of the felons, we notify on 3rd of February.
Obliged.
Third February.
हो गया, हम लोग तो-
Yes,
Yes,
please, your lordship. My lord, with the consent of the respondents, my lord, I beg to mention item number 31, which is fixed for hearing today.
yes.
On behalf of the appellant, my lord, we were required to file written argument. My lord, I need to file my written argument today, my lord. I have
As
prepared it.
prayed for on behalf of the appellant and agreed to by the council for the respondent. Let this matter come up for consideration on any Wednesday after 2 weeks.
Twenty-six two.
I'm so obliged, my lord. I'm filing my written argument today, my lord. I'm so obliged.
Any other request?
May I please, your lordship?
Yes.
Lordship, in item number 22, I'm appearing for the respondent number 8. So I have filed an affidavit in opposition. Let me be called for it. Deeply obliged.
I seek my lord's indulgence to mention a matter for listing tomorrow.
What is that?
A contempt matter, lordship,
Contempt of which order?
uh,
When was the order passed? What
Twen-
was the time limit?
26, 2025, this
Mm.
honorable court led division bench of Justice Surana
Mm.
had passed the order directing reinstatement of the petitioner within 50 days. That is yet to be complied with. Lordship.
Oh,
And
Tomorrow.
it has to come before the appropriate bench.
May it please your lordship. Lordship, listing of two connected dispose of writ appeals, your lordship.
Why?
In those writ appeals, your lordship was pleased to upheld the compensation of rupees 1 lakh to a medical student for loss of his one academic year. And in that very judgment, your lordship was also pleased to observe that if that compensation is not paid within a period of 4 weeks, student will file an affidavit and which will automatically revive the writ appeal.
They have not paid you.
No, your lordship.
Mr. Borpujari was there, no?
Uh,
Who was the lawyer appearing in that matter?
Mr. Social Welfare Department and Health, your lordship.
Mr. G. Gogoi. Anyway, it is revived.
Lordship,
Let it be listed.
lordship. On Friday, your lordship,
Next week, Monday.
lordship, oblige, your lordship, deeply oblige.
Second, revive.
Just inform the lawyer, Mr. Borpujari, you have to inform the lawyer. There was a matter where because of the fault of the university, the candidate lost a year or two. Way back, a bench of this court, not this court, but a bench of this court passed an order directing the person to be paid 1 lakh. That was appealed against. We did not find any favor. It was a long time, pending matter. Till date, it has not been paid. Just inform him, we are going to enhance this and we'll get it recovered from the person who is responsible.
Well,
The state will not be required to pay now. The person concerned who has kept the file with him will direct for its recovery unless on the next day when the matter is revived. Fortunately, we passed an order on that day because you appear for the state, therefore we are telling you. We passed an order that if it is not complied with, a 2 pages affidavit would entitle the petition to be revived. So that's how it is being revived. You tell the concerned person that he should do it before that. Otherwise, we increase the compensation, we record, and we may initiate contempt.
My lord. I will.
You can't ignore court's orders like this.
Absolutely.
And the
absolutely.
order traveled up to Supreme Court, there was no interference.
Absolutely. I will.
Maybe. Lordship, one fresh writ appeal, one fresh listing.
First,
Lordship.
yeah,
Yes.
what is the matter?
Lordship, because some of the petitioner case already considered by the Honorable Lordship. Regarding Lordship, they are the employee of the bar unit of Dhubri Civil Hospital. Lordship, remember. Lordship,
No new case.
no, Lordship, out of the same judgment, some person are left.
Only those who had come. Now we can't keep on extending.
No, Lordship, out of the same judgment of the single judge, Lordship, some persons are left, Lordship. Your Lordship also.
No, we have said that.
Yeah.
Now, please refer to the order.
Yes.
We have said that all those persons who had filed that petition, though
No, Lordship, kindly see, Lordship, the order, your Lord is. Otherwise, Lordship.
no, we are not doing it.
Lordship, otherwise the government
Will-
also, Lordship.
It'll come in its usual course. No urgent list. Now you people sleep over your matter when we force it down the government, then you wake up from your slumber. No, I'm sorry. Let it come in its usual course.
Okay. Okay.
Daily list for orders, item 1.
May it please your lordship. Lordship, in this matter, we received our instructions on Monday, lordship. Lordship, I pray for 1 week's time, lordship, to bring the same on record.
So have we passed some order?
Lordship, to bring the present status on record as well as regarding the
Just a
lordship.
minute. Let us go through our order.
24/10/25, Miller. There is a long order.
Paragraph? Can I make it?
Para 19, Miller.
Proceed.
এতিয়া দুলারের ঋণ বালিকা হবে teacher স্কুল
MS P. Barua, learned advocate,
Huh?
has submitted that the instructions for filing an affidavit, including an updated status report on the projects said to have been initiated by the state towards carrying out the project for arresting the artificial flooding in Guwahati city, has been received, and the affidavit shall be filed shortly. Let such an affidavit be filed positively with a copy in advance served upon Mr. K. Chaudhary, led
Well,
senior.
let the matter come up in the month of May, Miller, because then that is when we will get to know how effective are the measures taken.
Not later than 2 weeks,
Yeah.
not later than, not later than 25th of February. List this matter.
May I make it? I'm sorry. I'm extremely sorry. People notice fixes the date. Peter.
Ah.
I have flagged an issue para 18, my lord. Para 18 of your lordship last order. There is also a status report was transferred from the state. Now the issue is that after your lordship last order, the school is doing the construction in a work footing. And apparently, my lord, the construction done by the school is without any permission and without any.
So again, one school which was being constructed over the drainage.
I'll only pray lordship will not fix the matter in the month of May, since they have said that by Monday they will file their affidavit.
Right.
Any date in the
Right.
next week.
The 25th of, by 25th, nahin, ho gaya, yeah. Positively by, today is what date? Positively by 6th of February, let this matter come up for consideration on 11th of February.
Deeply obliged.
And I'm sorry.
Item number
We
2,
didn't
sorry.
Stop the construction.
No, lord, what they are doing.
No, did we pass any restraint order?
No, lordship, no. Lordships on the last occasion wanted some instruction, information from them. What is the status? If your lordships considers the report and pass some order, Miller will be glad. Not only
We will
the.
pass order for the benefit of people, not for the happiness of Mr. Das.
No.
But
it's not that-
if there is permission, then we are not passing any
Fine,
restraining.
lordship will not pass any lordship. We'll have to check only whether there was permission or not, my lord. If there is no permission.
Which
lordship will-
paragraph did we
Paragraph
refer to?
18, my lord.
Para 18, nine. Nine. So, nine. Every department is consulted. Para 18, nine.
Now, the updated report should include something about this also.
Lordship is
So lordship will kindly consider that and I'll urge upon your lordship to pass some order.
Let's see what is there after.
Fine, my lord.
We would. If there are no permission,
Yes.
the construction is going on, otherwise also it is going to block the drainage, we shall pass an order.
Yes, ma'am. Highly obliged.
But before passing any order, you'll first pass a restraining order. We would have the
Correct.
the owner or the principal pleaded as a party. We
Correct.
will issue notice. We'll not ask for demolition straight away.
No, no, no.
That will
I'm
have-
not asking. Oh, what I'm asking is that, my lord, after
Let's
2
see.
months, if they finish the construction, there'll be a point of no return. That's.
No. That is not the situation with this court. If you do something wrong, it has to be rectified.
I'm glad, my lord.
Whether
I'm glad
building
for
is to
this.
be
I'm-
taken down doesn't matter.
My lord,
And
I'm
we have precedents. You
Yes.
remember the Goa case,
Correct.
the Kerala case.
correct, my lord. Correct. My lord. I'm grateful, my lord, for this view. Much obliged.
Item 2,
Report not.
Awaiting the service of notice on the sole respondent, the matter is adjourned to 20th of February. Or sometimes in March. Give the date.
13 March. Item 3,
What is that?
Records have been already given to the register judicial, my lord. Yes, the.
My lord,
20th of
reconstruction
January.
process is on, my lord. We need some time, my lord.
Already from our side also we have given.
They are also
Already given.
cooperating, man.
Mr. Bashal and Standing Council Guwahati High Court submits that the process of reconstruction of records, which had hitherto been missing, is on. Some more time would be required for reconstructing the entire record. List this matter under the same heading in March, 15th March,
Deeply obliged.
on so and so day.
23rd March. Item 4,
May it please your lordship. The lordship will kindly turn to page 22.
the order. Whose order?
Page 22, down below, para 11. Has your lordship got it? In such
Page
circumstances,
22, yes.
we dispose of the writ petition with the direction to the Chief Secretary of the Government of Assam to constitute a three-member committee to be headed by an officer not below the rank of Additional Chief Secretary to the Government of Assam to examine the aspects regarding the violation of the master plan as well as the environmental issue, if any, that is likely to arise in the establishment of the amusement park of the construction of the hotel tourist complex, which is being leased out to the respondent number 9 of the municipal board by the municipal board. The said three-member committee shall conclude the exercise within a period of 8 weeks from the date of the receipt of the certified copy of this order and submit its report after providing proper opportunity of hearing to the parties to the writ petition, and also shall communicate its decision to them immediately after conclusion of the proceedings. Your lordship, we had submitted the same, your lordship. The forwarding was given, that is at page 24. It was received by the Office of the Chief Secretary on 10/3/2025.
Hmm.
And a reminder was also given, that is at page 28 on 16/10/2025, but nothing is forthcoming, your lordship.
Yeah.
We were the respondents in the PIL, your lordship.
You were the respondent in the PIL?
Yes, your lordship. There was a NIT floated by the Silchar
You were
municipal.
respondent number?
9, your lordship. In
Why
the,
is the person who has been leased out?
yes, your lordship.
Oh.
And there was a PIL.
You are grieving that the whole process has been delayed.
Yes, your lordship, because of the PIL.
Who appears for the state? Who appears for the state? Yeah, Mr. Beckman. Please take instructions.
I will.
I'll
And
serve
we
a
are
copy to
fixing
my.
it in the next week.
I have not
See, we are not, had it been the writ petitioner, perhaps we would have issued notice. Is the person who has to construct the amusement park and hotel not at his instance? No, not at his instance. Maybe the report would have been against him. That in Gandhi Bagh, no such amusement park is to be.
No, the report was in my favor. That's precisely honorable.
Anyway, let's take the.
Only on the environmental issue, if any, the
Instead
court
of
is said.
Notice in the contempt, we will first have instructions. But good you told us. I thought you are the petitioner.
No.
Good you told us.
It was directed to constitute a three-member committee.
Whatever. People of Silchar say that that would spoil the ecology of that place. And you are, pushing it hard for your business. Let's see, at your instance, we are not very willing to issue contempt notice. Let's see. MS Sharma, have you understood?
My lord, a committee was directed to be formed, my lord, and that what the government has done.
Initially, it was leased out to him. He was to take up the entire construction work and all. But then because of the intervention of local people, the court directed that committee has to be constituted, which will examine the aspects regarding violation of master plan and environmental issues and other things. So he says report is in favor.
No, there was two issues that was raised.
Anyway, you take
I
instructions and
will
get
take
back to us.
instructions.
Serve a copy to her.
Today itself, your lordship.
Let. Canon. MS S. Sharma, learned advocate for the state, has assured this court that she will take instructions in the matter and shall get back to this bench on the next day. Re-notify after 2 weeks.
Deeply obliged.
23rd February. Item 5,
Sorry. Yes.
33 days delay, lordship. 33 days delay.
33 days, will let notice be issued. There's an application seeking right to that. Robin? Application seeking condemnation of delay, issue notice to so and so on step being taken by the petitioner within a period of 2 weeks, both modes returnable. Your date.
March, 25th March.
Deeply blessed.
Item 6,
Condonation of delay, Lordship, is 305 days.
Mr. Counsel, in the first paragraph, you have said that you are challenging the legality. Second paragraph, you say that 305 days delay. And in the third paragraph, you conclude that you have a good case on merit as well as law, and as such, you would be prejudiced if the appeal is dismissed. 305 days delay, not a word about the reason for delay.
Lordship, paragraph,
No good ground has been made out. We are not even issuing notice. If you come to us so casually, not a word. You have summed it up in 3 paragraphs. Not a word, not even a line, no reference.
paragraph 3, Lordship, I'm reading, Lordship. Paragraph 2, Lordship. That the filing of the instant appeal is primarily because of the fact of the technical decision, Lordship. Paragraph 2, Lordship.
Primarily because of the fact that for taking decision and approval from the office of the appellant, this is, when was it sent?
El-
When was it?
Elaborate,
We don't look at it. If
Yes,
you have case on merits, we normally don't look at it, but this is no way.
Lordship, I do admit it, Lordship, liberty.
What
may be given.
liberty?
Liberty that to,
No, we are rejecting it now.
Lordship,
You don't have case.
liberty may be given, Lordship.
Then withdraw this application.
Yes, I will do it.
Mr. So don't be so casual about it. What
Lord.
is his name? Mr. J.K. Goswami, learned counsel for the appellant applicant, seeks permission to withdraw this application for condemnation of delay of 305 days with the liberty to file a fresh, appropriately drafted application for the same relief. Stop. Dismissed as withdrawn with the liberty of course.
Lordship,
We have been indulgent.
Lordship, Lordship.
supplementary list for orders, item 32 to 34.
May I please, your lordship?
Yes,
Lordship, I appear for respondents in item 32 and 34.
yes.
30, respondent number 1. In 32, we filed our affidavit in October. In 34, we are filing it in the course of the day. We've served
Today, just
We-
now I have
yes,
received.
just
a
now,
copy.
yes,
I have received
yes.
a copy, Lord.
and we are filing it in the course of the day.
The
32 and 34, 33.
I'm appearing. I've already filed my application.
all. Okay. MSG Goswami learned advocate has submitted that the affidavit on behalf of respondent number
1
1
in
has been filed today
Lord, I
Yes.
have received it, Lord.
where the copy is served upon Mr. K. Gogoi, learned advocate for the petition. Let it be tagged with the records of this case. List this matter for consideration. When do you want it?
Any day, Lord, see, as per.
When do you want it?
as your lordship, as per your convenience.
Twenty-sixth of March.
Oblige, your lordship.
Daily list for admission, item 8.
May I please, sir?
Daily.
Ajay, you come back to the system. We'll change the system now. Yes,
May I please, sir?
yes,
Worship, I'm aggrieved by the order of the learned single judge,
yes.
whereby I was denied interest from the date of retirement.
30 days after the retirement.
30 days after retirement. The honorable single judge did it, on the premises of section 7 proviso to section 7(3)(a, said that delay was on my part. So it has to be, the interest has to be counted from the date of application when I approach the controlling authority. But my submissions are, my lord, that there are two compliance under section 7 subsection 2, which they failed to do,
Hmm.
the employer.
Hmm.
They had determined my gratuity at 1 lakh rupees, which was itself at the very onset was illegal because under their own terms, internal rules and regulations.
You read the judgment of Supreme Court in Tarsem Singh.
I'm not aware as of.
The difficulty is that if we apply Tarsem Singh, then perhaps you don't even get that.
My lord.
Tarsem Singh says, which is being applied by all the tribunals and high courts, even Supreme Court
Hello.
across the board, that if there is a continuing wrong and interest has to be awarded, whatever be the reason, it should not be for more than last 3 years.
My lord.
So that way, the single judge has allowed it from the date when you file the petition,
My lord.
correct?
My lord.
And if we follow Tarsem Singh, it goes beyond. I mean, it is slashed down by another 3 years. Whatever you say, Tarsem Singh, are you aware?
My lord.
Tarsem Singh is 2008, 8 SCC 648.
But thereafter,
All
judgment of
judges
YK Singla, my lord, I'm sorry, that it's in 2013.
tell us, we are absolutely satisfied that the single judge has passed a correct order. You don't
Hello.
require anything more. Let's see Tarsem Singh.
My lord.
And you be satisfied, then you press this petition. We would follow, you would be given 10% interest on the delayed payment, but it will be only 3 years. Let's see,
Madam.
I'm also not remembering it exactly. It is 3 years prior to the date of filing or what let's see.
Seems to be what happened.
Normally a related claim. You reject the- One of the. Correct. One of the exceptions that. Even if there is a law. If such continuing wrong state, but there is an exception. With the grievance within the make the reopening of and like that. That's right, but from which time? Interest, otherwise according to section 7 should. Interest. That's fine. So it's not given. For example, if the input period payment of 3 granted today, but it's claim involved for last 3 years. So, leave related to areas 3 years before the date of it. So, people have given it yes, what judgment do you want to?
Manoj, YK Singla, S 2013 3 SCC 472.
What does it say?
Manoj. It says there has to be 2 compliance under section 7 subsection 2.
That's true. That even the single judge has taken note of.
My lord. And the delay has to be on my part. There are 2 ingredients in Manoj. I'd like to draw your attention to also paragraph 18. If I may read, Manoj. Paragraph 18, Manoj.
Paragraph 18.
18. Manoj, if I may read.
Yeah.
Subsection 3A,
You're referring to YK Singla, no?
YK Singla.
Another judgment has no. Yes, paragraph 18. Read it loud.
Manoj. It was read. subsection 3A of section 7 of Gratuity Act is the most relevant provision for the determination of the present controversy. A perusal of subsection 3A leaves no room for any doubt that in case gratuity is not released to an employee within 30 days from the date the same becomes payable under subsection 3 of section 7, the employee in question would be entitled to simple interest at such rate not exceeding the rate notified by the central government from time to time for repayment of long-term loans, as the government may by notification specify. There is, however, one exception to the payment of interest, and which is under subsection 3 of section 7 of the Gratuity Act. The aforesaid exception is provided for it in the proviso under subsection 3A of section 7. A perusal of the said proviso reveals that no interest would be payable if the delay in the payment is due to the fault of the employee and the employer has obtained permission in writing from the controlling authority for the delayed payment on this ground. The exception contemplated in the proviso under subsection 3A of section 7 of Gratuity Act incorporates two ingredients, where the ingredients contemplated in the proviso under subsection 3A are fulfilled. The employee concerned can be denied interest despite delayed payment of gratuity. Having carefully examined the proviso under subsection 3A of the section 7 of the Gratuity Act, we are of the view that the first ingredient is the payment of gratuity to the employee was delayed because of some fault of the employee himself. The second ingredient is that the controlling authorities should have approved such withholding of gratuity of the employee concerned on the basis of the alleged fault of the employee himself. None of the other subsections so and so would have the effect of negating the conclusions thereon. But in this case,
Just a minute, please.
the para 19 is also. I'm sorry.
Okay. वही देखा क्या देखा पेमेंट तो he expected it because she has no idea. इसको पढ़े लिखना वो लिखा नहीं therefore the chief did not complete. Most relevant problem. Take it. And the controlling authority. Because no government. The controlling authority. And then they will inform. The learned single judge has taken a different view, which is quite plausible. I mean, which is quite acceptable to us.
My lord,
Prima facie for the reason
my lord,
that a conjoint reading of section 7,
Right.
1, 2, and 3A, it casts a duty on the employee,
Right.
not the employer, to tell on superannuation that this is the amount which I must get in gratuity.
my lord,
And thereafter, the employer writes to the controlling authority, informs and
Right.
pays.
my lord,
So all this has to be done within 30 days.
Right.
You don't do anything,
my lord,
right?
my lord.
So they calculated the gratuity not in accordance with the
The Gratuity Act.
Gratuity Act. They said that you are entitled only for 1 lakh rupees. You accepted, you were very happy.
Right.
It was only later when you learned that others are getting more, you made an application before
My
the
lord.
controlling authority. This was in 2024.
My lord,
So there was a corresponding duty for you also to remain vigilant. You lack of knowledge of law is no defense.
my lord. My
You
lord,
know
but there are two compliance under subsection 2 of section 7, my lord. They had to inform the controlling authority also.
Right.
They didn't comply with it.
They have to inform the controlling authority on your application.
No, no, my lord, they have to,
No.
my lord, kindly, my lord, I'm supported by the judgment of the Supreme Court in this, in relation to this section.
They have wrongly done it. So wrongly done, but they did not ask it. Yes, sir. We are only interested for that interest from 2000.
My lord, the gratuity has been paid.
We have followed that.
Yeah, my lord, sir,
10% interest, not from 2024, but from 2019. You don't need to
2019.
repeat that argument every time.
my lord, I'm sorry,
We are looking at it. Why do we give you? That is the whole reason.
my lord.
This is not, as soon as become payable, it is not contingent on his right. The employer shall, they will not determine the amount of gratuity and give notice and right. So that is gratuity. And also to the controlling authority. Have they sent it to the controlling authority?
My lord, that has not been done.
That has also.
That has not been done.
And the employer shall arrange to pay their mortgage. So that has not. Otherwise, the controlling authority would have done that.
My lord, had they done it, the controlling authority would have given an objection, my lord.
Correct.
That this is wrong gratuity paid under the act. So, my lord, that is my humble submission, my lord.
We'll do. We will do that. The notice has to be issued.
My lord.
Probably. If you're ready for now, this is statutory. Oh, no, school also. The management.
School is,
I mean, record. Against the judgment dated. Also passed by a learned single judge of this court. In WP number so and so, whereby the order passed by the controlling authority, namely the order passed by the controlling authority under the Payments of Gratuity Act has been interfered with, and the appellant has been directed to be paid interest on the gratuity amount only from the date of only from the date of her having filed necessary application before the controlling authority. Pete noted that the controlling authority had directed for payment of 10% interest on delayed payment of gratuity, which accrued in favor of the appellant 30 days after her retirement. The appellant had retired after 36 years of service in the year 2019. Paragraph the The school management paid her only 1 lakh rupees as gratuity, which was willingly accepted by the appellant for her lack of knowledge about her entitlement with respect to gratuity. It was only later in 2024 when she learned that she was entitled to more amount as gratuity, she had approached the controlling authority, who in this case is the Assistant Labor Commissioner, to claim full gratuity amount. Her request was acceded to, and an order was passed in her favor that she would be entitled to a gratuity amount of approximately 5 lakh rupees, along with an interest of 10% for the delayed payment. Notwithstanding the availability of an internal forum for challenging such order passed by the controlling authority, the school management preferred a writ petition by WPC number so-and-so, wherein the learned single judge, by the order impugned, approved of the decision of the controlling authority to pay the gratuity amount to the appellant in terms of the Payment of Gratuity Act 1972. But interest on such payment at the rate of 10% was made available to the appellant only from the date when she had approached the controlling authority for the need for it, and not from 30 days from her date of retirement in the year 2019. The logic employed by the learned single judge is that on a plain reading of Section 7 of the Act of 1972, of the Payment of Gratuity Act 1972, it was incumbent upon the employee / appellant to have intimated the authority to receive gratuity amount. The management, authority name management. The management, on the other hand, had also a corresponding duty to calculate the gratuity amount payable to the employee. And simultaneously, a permission had to be taken from the controlling authority. The learned single judge opined that both the requirements under Section 7 of the Act were not fulfilled, and therefore the delay in payment of gratuity to the appellant was because of her own fault of only approaching the controlling authority in the year 2020. Precisely for this reason, the interest on the delayed payment was limited only from the date when the aforementioned application by the appellant / employee was filed with the controlling authority. The learned counsel appearing for the appellant, however, has submitted that the purposive interpretation of clause 2 of section 7 would indicate that there is a duty on the part of the employer to calculate the gratuity amount in accordance with the Act of 1972, which in this case was not done. No sooner the appellant realized that that she was paid much less than her entitlement, she approached the controlling authority, whereafter necessary order was passed. It was under such circumstances that the controlling authority itself directed for payment of interest on the delayed payment from after the 30th day of the retirement of the appellant. In such circumstances, the learned counsel for the petitioner submits, the order with respect to interest should not have been interfered with. Let notice be issued to the management.
My lord,
Respondent number.
respondent number 3, there is a private school.
Let notice be issued to respond number so and so on steps being taken by the appellant within a period of both modes returnable and so on. Notice to response number 1 and 2 is accepted by M.S. Sharma. Learned, your government advocate, learned government advocate, who shall also put in her response by the next day, if deemed necessary. 2 weeks, about 2 weeks, 4 weeks.
28th March.
There is a, I'm praying for a stay of the impugn order. My lord. There was a direction to pay the amount.
No, let it be paid, we'll pass.
Still,
You've got your gratuity amount, it's 10% interest.
My lord,
So we are not going to stay, otherwise everything would be stay.
my lord,
We are not making it a conditional stay. Now,
Well-
let her be, I mean.
if
you
they
will be-
pay, my lord, if I accept it,
No. It is by virtue of this order.
my lord. My lord, item number 9 is also similar, only the date of retirement is different, my lord.
उसी तरीके से date of.
31/3/2021.
And she is also a lady.
Lady, same teacher from the, her years of service is 40 years, my lord.
Well, some necessary changes. देखकर necessary changes.
I'm deeply obliged.
item 10,
हटाने का।
My lord, by filing this writ petition, my lord, we have challenged the, my lord, judgment and order passed by the tribunal. I am presenting caveats. The order, my lord, which was challenged by the respondent, my lord, on the ground that this is not an innocuous order, not a order simpliciter. And our stand was that it is absolutely, my lord, in terms of the clause 5 of the appointment letter. Therefore, whether it is a, my lord, order simpliciter or it is punitive order, this is the question involved, my lord. And tribunal has come to the
Just,
conclusion.
can you give us 5 minutes, Mr. Protest?
My lord, my lord.
बदमाश respond. लेकिन वो कह रहे pragmatic हो गया ना. It is not for the purposes of evaluation. Assess the overall suitability of inquiry report. Suitability. Shows the memorandum of appointment.
My lord, appointment at page 87.
Page 87.
No, my lord.
No,
No,
memorandum
no,
of
no,
appointment.
no. Appointment, huh?
Wait, section 5A, not 5.
112 পঁচিশ।
Huh?
93, my lord.
91, 93.
That copy,
Until he is confirmed, it is that terminable by 1 month notice, until like, without any reason being affected. Okay. And where is that report,
inquiry report,
inquiry report?
inquiry report,
Fact finding inquiry report,
Fact
inquiry
finding.
committee, not inquiry.
yes,
Fact finding inquiry
Yes,
committee
madam.
to assess the suitability.
yes,
Where is that?
140.
It's. Pragmatic होगा तभी sketch photo तो. Show us.
Hello, 140, page 140. The element part is 144. Conclusion part.
Relevant part is not necessary for us. The report as per the number. Fact finding inquiry was completed. Pertaining to unauthorized airport completely unauthorized, there should be another to evaluate. So that this is different. And where is the order?
Order is at page, my lord. Order, which order, my lord?
1 second.
Tribunal.
The 107 is what?
Implement order 87.
This book.
Here. Appointment order. Appointment order. Implement order 87. There must be a picture problem.
The minor penalty. Hear me. Penalty उससे जो penalty तो हो गया अब ये 140 है ये रिपोर्ट और वो कहाँ है इसका पहले हम देखते हैं कि क्या लिखा है I wanted to know fact finding inquiry report. तो ये बात interesting है इतना तो पक्का है notice for operation and there are 1 month notice to make it. So the appointing authority covered reserve for a permanent to project. Then before the expiry of stipulated period notice by making payment of equipment, but otherwise notice. तो पहले करते हैं नोटिस तो देना Stigmatic for okay. Mr. Prakash, we find this removal to be very, very stigmatic. And therefore, we are inclined to endorse the view of the tribunal.
Madam.
What do you have to say? One, you did not give her a notice.
My lord,
Clause 5 reserves the right to an employer,
right, my lord.
even before the conclusion of that notice, to terminate.
My lord, lordship kindly appreciate one thing, my lord.
Number one.
When
Number two,
inquiry was conducted, notice was issued to him, he appeared, he filed WS.
sir, that is
Therefore, he was quite aware of the
you are-
fact that,
you are inflicting self-goal.
my lord,
That inquiry, if you refer to that inquiry, we'll call it to be stigmatic. We will go by the tribunal's opinion. Plus, you have not done your part. You have to issue notice to her, number one. And before that notice also, you could have done that, but notice was a must. That is not clause 5 of the memorandum of appointment does not do away with the requirement of notice. Correct?
My lord, issuance of notice is not a mandatory requirement. It's not a mandatory requirement, my lord, if the order is simplicity in nature, in terms of the order itself.
Yeah, shows that part of the, shows the peroration of the cat. The denouement, the last part,
Last part of which order, my lord?
tribunal,
Or tribunal?
which you have challenged.
Tribunal, my lord, arrived at a conclusion that the department,
Where-
the inquiry which was conducted, it is not a departmental inquiry.
Just
Yep.
207. The entire fact to value. वो कैसे पता चलेगा? तो background fact ना? पर वो कैसे पता चलता? लेटर से तो नहीं पता चलता ना, ये लिखी है।
Para 41 ওকে যখন থেকে জানতে লাগে তখন সময় আমি স্কুটি অর্ডার পাস করব তখন জেল কেস রিকোয়ার
नोटिस कर दो। Finding of misconduct on the basic foundation of कौन सा जजमेंट है वो? बेसिक फाउंडेशन कौन जजमेंट तुम लोग दिया Yes, we are not inclined to interfere.
Lordship, kindly appreciate, my lord, a full-fledged inquiry is required when the misconduct is the foundation of the decision. Here, the misconduct is not the foundation of decision. We have inquired into, my lord, by conducting an inquiry. In order to, my lord, ensure the fairness.
This argument itself makes your case weak, no, Mr. Portais.
My lord,
Therefore, the motive is punishment. The motive is not to assess the suitability.
my lord, at least one
You are
decision,
relying on that. What is that judgment, the famous judgment, Jaswant Singh, or
my lord,
how it is to be assessed? What is the basis?
Judgment Singh says, man, there is a number of references in the Judgment Singh's case, my lord.
Hmm.
Court says, Supreme Court says the language is the criteria. What is the language, my lord, used in the termination order? If the language is innocuous and language does not, my lord, indicate anything,
Dipti Prakash Banerjee, that is the case.
and he was given adequate opportunity to improve his, my lord, performance. He failed. এটা না, এই judgment টা না, আরেকটা আছে দেখুন। আমারটা দেখো না, দাগ দেওয়া আছে, বোর্ডটা দাগ দেওয়া আছে। লিখে রেখে আসলাম তো এটা না এই তো।
चलो क्या करते हैं मतलब हम पास आएगी ये तो दूसरी वाला पेपर no we are not in ठीक है
My lord, may I submit one thing, my lord?
now if we had some way we would have issued notice to the respondent but then you have not been able to make out a case and in fact what you are arguing is only weakening your case all the more
My lord,
and you had that experience before the tribunal
no,
for
lord,
the reason of your argument
My
I
lord,
mean,
lord-
of the argument of the
my
lawyer
lord,
there, he was
lordship-
always referring to that departmental proceeding
lord.
the inquiry proceeding and all that
My
so
lord, lordship,
the law permits the courts to lift the wheel
right,
and lifting the wheel makes us very sanguine that you have punished her for her misconduct.
My lord,
Not
lordship is to,
for, it's not an innocuous order of termination under
lord.
clause 5 of the memorandum.
my
of
lord,
appointment.
lordship is to lift the veil in order to, my lord, get
Hold-
satisfaction.
hold Inquiry.
But the
throughout the-
inquiry is only for the purpose of imposing penalty or establishing misconduct or for anything else. And Supreme Court says, my lord, even though order
You're talking,
seems to be
Mr. Prakash is
stigmatized,
arguing just the opposite of the law.
my lord,
Just the opposite of the law. See, just one thing,
lord.
1986.
Judgment Singh I am referring, my lord.
Ah.
Judgment Singh says language is the, my lord, basis. Or is to look into the language of the impine order. Then Supreme Court again says, my lord, referring 2002 judgment.
Language is very innocuous. It
Language
says
is very
you're not
innocuous.
terminated.
Therefore, language is the basis. Otherwise, my lord, otherwise, the holding of a, my lord, inquiry, it is not, my lord, unknown to law. I can also hold an inquiry in order to get satisfaction.
We have heard Mr. Canon. We have heard Mr. A.K. Prakash Lan-
Lordship may can issue notice and, my lord,
No.
examine the matter.
We were contemplating to, but your argument before the tribunal, your argument before this court, you're not able to make a distinction.
But I say that, my lord, this is an absolutely innocuous order and the inquiry was conducted
No,
not
no,
for,
you have made a different statement before the tribunal.
that's right, my lord. Now, that was a, my lord, I think, my lord, they had misdirected themselves. Misdirected themselves.
What to do? We have to,
For the answer of justice, my lord,
law is law. We don't ask you to keep her.
my lord,
Give her an inquiry, full-fledged inquiry, terminate her. We have no issues.
then my lordship may kindly make the observation.
We will.
Kindly they make that observation.
No, we will not say about, we are not supposed to advise you. We will not interfere with the tribunal's order. Tribunal says so.
My lord,
Ah.
if tomorrow they
We
will
have
come, my lord, they will put an embargo, my lord, saying that
No embargo, nothing of the kind.
you cannot go for further inquiry.
No. There is the petition is dismissed.
Otherwise, it is a very good case, my lord, wrong submission made before the tribunal. That is, my lord, small.
The respondent is not a good teacher, not a good principal. We agree, but we have to follow law.
My lord,
The respondent is absolutely undeserving.
my lord.
She had gone on leave and whatever.
Yes, sir.
But then the law is to be respected. No, you trigger that clause 5 of the memorandum of appointment.
Right.
And before that, you are holding inquiry and you are punishing.
Therefore,
And
my
you are
lordship,
referring to that before the tribunal.
lordship,
You should have said that this is the background fact and therefore we found her to be unsuitable and therefore we have exercised our option under.
My lord.
Notice convenience.
but at the same time, court needs to be satisfied. What is the purpose and object of holding the inquiry?
See, look at, because of the conduct of the respondent only, we are issuing notice. Otherwise, it's not required.
My
We
lord,
are very clear on law.
my lord,
But then we will also record our observation.
my lord,
Hmm.
my lord.
Like, yeah, the petitioner slash Kendra, we have heard Mr. A.K. Purkayas, learned senior advocate,
Not designated, my lord.
Mr. Senior in your own right. So
Wow.
Mr. Purkayas, learned advocate for the petitioner.
I'm obliged.
The the petitioner slash Kendriya Vidyalaya Sangathan has come up before this court against the order dated 12/11/2025 passed by the Central Administrative Tribunal, Guwahati Bench, in OA number 94 of 2025, whereby the termination of the respondent number, termination of the sole respondent, termination of the services of the sole respondent from the post of principal,
Grade two.
from the post of vice principal, from the post of principal grade 2 of newly opened Kendriya Vidyalaya BSF Gokul Nagar, Sipahijala district, Tripura, has been interfered with and a direction has been issued for affording her a full-fledged inquiry before terminating her services.
For him. Made man.
Including the wages for the period. Acha, nothing, no. I thought full-fledged inquiry was ordered.
But
No, then we'll issue. क्या लिखा है पढ़ो? नहीं. The termination order has been set aside. Mr. Purkayas, learned advocate, has argued that though a departmental proceeding was initiated against the respondent, which ended in her being found guilty, but the present termination was during her period, during her period of extended probation on a general assessment of her unsuitability for the post. It has further been argued that in substance, the petitioner slash Kendriya Vidyalaya Sangathan has only enforced clause 5 of the memorandum of appointment, which reserves the right on the employer to terminate the services of an employee during the period of during the probation period with 1 month notice or a month's salary in lieu of such notice. That the respondent was subjected to a disciplinary proceeding in the past did not weigh with the petitioner for exercising the option under clause 5 of the memorandum of appointment of the respondent. Thus, Mr. Purkayast concluded that the tribunal misdirected itself in holding the termination to be founded on allegations of misconduct rather than mere unsuitability. Stop. No doubt, while scrutinizing such order of termination, a court or tribunal can lift the veil, but in the present case, Mr. Purkayast argues events occurring in the distant past have been conflated with the issue of suitability. Unnecessarily, I'm putting words in your mouth. This is not what you have argued. You have argued just the opposite of it. Because the conduct of respondent, we don't find it to be good, therefore we are issuing notice. Otherwise, we would have dismissed it. What did I say? Events of distant past have wrongly been conflated with the present assessment of unsuitability of the respondent. Let notice be issued to the respondent on steps being taken by the petitioner within a period of 2 weeks, both modes returnable on chance. Till such. Are you praying for stay?
Yes, my lord.
No, you can't hear in statement. Till the next day, the order passed by the tribunal shall remain in abeyance.
I'm extremely grateful, my lord.
25(3). Item 11.
May it please your lord. My lord, we are also assailing the virus of the rules, my lord. Rule 19(2), it envisages only interview, my lord.
No, this is item number 11.
Yes, my lord. This is regarding, my lord, selection of public prosecutor additional.
Where some lawyer wanted to be, she wanted to withdraw her wakalatnama. Yes, come. We were very happy that the entire petition was being withdrawn. What do you want?
See, you filed the wakalatnama for respondent 40.
क्या नाम है आपका? What is your name? Mrs. MSB Sinha, ऊपर में लिखना. MSB Sinha Learned Counsel for respondent number 40. Submits that she does not wish to remain an advocate on record for the aforementioned respondent, and therefore she prays for permission to withdraw her wakalatnama on behalf of respondent number, filed on behalf of respondent number. Permission is granted. The name of MSB Sinha Learned Advocate be not printed henceforth in the cause list. If the case be not printed henceforth. Yes.
Yes. My lord, basically we're assailing the virus of rule 19(2), my lord.
19(2) says what?
Yes, please come to that rule, my lord.
These are rules of 139.
309 rules, my lord. Page 109. And the operative portion is at page 112.
These 309 rules are called
133. Page 133.
My lord, the rule is called
Prosecution service.
133.
Assam State Prosecution Service Rule
Oh.
2023 at page 133.
1 second.
Yes.
Assam State Prosecution Service Rules of 2023. Yes.
Yes.
And which section do you want us to?
My lord, Rule 19, 19, my lord, at page 139.
Hmm.
Selection of candidates for direct recruitment shall be conducted by the selection board to be chaired by a retired judge of the High Court and other members as may be notified by the state government from time to time.
Hmm.
2, evaluation of the candidates with substantial experience for highly skilled roles like public prosecution would require a specialized testing for assessing the requisite qualities, drafting skill, analytical and presentation skill, mental agility, and quick grasp of the arguments and quoting judicial precedents, etc. Accordingly, the selection board may devise appropriate method of proficiency cum skill test by conducting a viva voce test. So only, my lord, the mode of test is that viva voce. There is no element of written test, no nothing. Then my lord will kindly come to sub-rule 6 at page 140. They say, my lord, the merit would be the only criteria. How to assess the merit? These are all subjective. After holding the examination, the selection board shall select the candidate in order of merit, taking into consideration a reservation SC, ST, OBC, MOBC and other categories under Rule 7. Well, the end result is 7,000 candidates were interviewed for 299 posts. There was no cutoff mark. There is no nothing. There was a stipulation that the candidates who have left practice will not be selected. We have given example of up to number of candidates who had even members of Foreigners Tribunal, even somebody who is presently also working in the High Court in Legal Services
That's
Authority.
true, Mr. Chaudhary, you would appreciate. Wrong selection does not make the rule bad.
No, its rule is bad, Miller. I'll say so, Miller.
Yes. So
Now,
therefore,
now,
that-
yes. Now,
we
please
will-
come
we
to
will
the
not-
advertisement.
Just a minute, we will not go on that
Yes.
presently.
Yes.
Otherwise, you go before the single judge.
No, yes.
You go before the single judge.
Yes.
Now, if you're challenging the rules
Yes,
per
yes,
se, then we in division bench will hear it.
Correct.
Now, therefore, how wrongly the selections were made is not our concern presently.
Precisely.
We
No,
will
I'm
see-
just, as an incidental argument, Miller.
That's right. I just wanted to make it clear.
Correct.
I was getting, I was only thinking that why are we hearing this?
Yes.
If it relates to those facts.
Yes.
Now, tell me why the rules are bad.
The rules are bad because it does
just a
not
minute.
prescribe written test
No,
number.
that is not the
No, no,
law.
I'll show, Miller, from the judgments
Now
that
come-
there's a requirement.
Come to 19.
Yes.
There is a requirement. It says that viva voce is very rudimentary kind of test where you can't adjust the personality. Therefore, you can't assign very high marks. That is the judgment. It doesn't say that written examination is a must.
Miller-
No, otherwise
Yes.
also. Just a minute. Now, 19.2 says accordingly, last part, accordingly, the selection board may devise appropriate method of proficiency cum skill test by conducting a viva voce.
Yes.
Viva voce does not only mean the candidate made to face a board of 5 question askers. No, they can give a presentation. They can give a fact situation like you know about the old. What is that? Seplusion explorers case.
Miller, let me make my arguments, Miller. I know, Miller.
Hmm.
Anjar Ahmed, Supreme Court said that, Miller, first of all, let us come to Ajay Hasia. Ajay Hasia was a case, it pertained to admission to educational institution. Then in Liladhar, for the first time, Supreme Court said
Please
a
refer to
distinction.
that. Those are admission.
No, I'm coming, Miller. Distinction has to be made between an admission to an educational institution and recruitment to public service. Then came Miller Ashok Kumar Yadav's case. Then that Saini's case, Mohinder Garg, Sain Garg. In all these cases,
You'll have to show these cases.
yes, I'll show. Now, Miller, my whole submission is when it comes to, Miller, interview component, Supreme Court has said that 12.5 is the maximum. There has to be a now, Miller, for example, when High Court conducts grade 1 and grade 3 examinations, High Court, prescribes a preliminary test followed by written test and viva voce.
When we grant silk robes to advocates, only interview, no written test.
No, my lord, true.
Because your experience at the bar,
No, my lord.
that is
No,
taken into
I'll show one thing, my lord. Please come to the advertisement. Here I'll show, my lord, why the entire process is wrong. Please come to the advertisement. At page 112.
Why did I take the example of senior advocates gown?
Yes.
In fact, we have not even been interviewed.
Page 116, my lord.
Huh?
Page 116.
Yes.
It's a call letter, my lord. Now, Lordship will kindly test whether there was transparency and fairness in this election. Serial number 5 and 6. Every candidate shall be required to produce before the selection board at least one copy of any application, petition, appeal drafted by the candidate himself, herself, and filed and registered before a court of law in a criminal proceeding. Every candidate shall be required to produce before the selection board 4 copies of any order, judgment passed by a court of law in any criminal proceeding in which the candidate himself, herself appeared, conducted, and argued the matter. Now, why this requirement was not made a part of the application itself? Now, today, my lord, when somebody shall raise a challenge, how does the court of law, my lord, examines that? Is it called transparency? My lord, this should have been the part of the application. Then it would have formed part of the contemporaneous records. My lord, merely because the selection is made by a retired High Court judge, it doesn't make any difference, my lord. End of the day, it has to be tested on the anvil of Article 14 and 16. Now, my lord, kindly see, now who knows whether this gentleman came up with this or not? So that's why it is said, my lord, why a reason speaking order is required? Because we get to know the reasons.
Even without. You see, Mr. Chaudhary, so we will not be importing our experience here. Whatever legal arguments you advance, we will decide it on that. But in consumer protection scheme, we asked for an interview of the retired judges for making them presiding officers. There was some rule. Just the rule came into existence via Supreme Court judgment. No judicial officer is ready, and therefore most of the posts are lying vacant.
No, my lord, that's a different aspect. Now, question is, my lord, here
Question is this.
My lord, no, I could follow, my lord. I could have gone to land single judge because there are a lot of anomalies. But I want to nip at the bud, my lord. Why this type of rules should come up, my lord? Why not written test? Why not you test, get the best of the lot, my lord? My lord, there are certain things I will not disclose, but this is not selection, my lord. This is just pick and choose. If necessary, we will file an affidavit. But for the present, we have restrained ourselves.
It is not going to unsettle us.
Yes.
The difficulty is that these appointments are as spoils. These are largesse. This is you have to read Justice Markandeya Kadzu's judgment. How this has been made.
No, my lord, I can appreciate the post of Advocate General and my lord and the like. But not this post, my lord. End of the day, they will be paid out of the funds of the state.
Look at it from a different angle. Government is a party. The party has a choice. But here that argument will not apply because it's a duty of the state to defend a person who cannot defend himself. So that apart, but its written examination is something, unless you say that it is required within a statutory framework, it doesn't get down well with us.
No, my lord, I know, my lord, the proposition which I am advancing is not very easy to accept it. That I know, my lord, because in Anjar Ahmed, Supreme Court said that yes, when it comes to public recruitment, it can be 100% by interview. But that was in 1994. Today we are in 2026. Things are not going in the way we desire. My humble submission is, my lord,
Show us any law which says, which talks about this in a public.
yes, I'll show, my lord. First, I'll place, my lord, Ashok Kumar Yadav's case.
Anyway, we'll hear it on some other day. Prima facie, we are not, this argument is not appealing to us.
No, my lord, I know it's a difficult argument. I do appreciate. Because we're questioning the wisdom of an authority who made this election.
So
End of the day, no, my lord, kindly see the procedure. Now, where is the transparency in this election? That's why I said, my lord, see, merely because a retired judge has made this election, that will not take away your lordships. Yes,
not even looking at that.
yes.
We are on a bigger issue that if in these appointments, these are for a tenure, 3 years, 5 years, I don't know, 3 years.
No, my lord. Yes.
It's section 24.
Huh.
Oh, not APP.
Yes.
It's not a question.
The rule has been framed under section 20.
Now tell me one thing.
Yes.
I thought it was APP, the government appointment.
No.
Not under 24 CR. That you could not have insisted for. But you tell us about other states
Okay.
where there is, you
How-
can
how-
make that argument that in all other states, because I remember in Bihar, I think written test is taken.
Yes.
So you tell us.
I'll find out, my lord.
Hmm?
We'll find out.
Actually, it is not for a tenure, a substantive appointment with retirement.
Full-fledged.
Yes, Mr. Naik. I was till now, I was under the impression that it is this, the appointment by the cabinet of additional public prosecutors for sections.
These are regular appointment. Now, Lordship, this petition is before this bench, Lordship, division bench, because of prayer 2, wherein Lordship, the barriers of Rule 19(2) has been silenced. It's only because of that prayer. So far as the other prayers are concerned, yes. If Lordship comes to the advertisement, Lordship, it starts from page
No, advertisement.
Lordship.
Answer to the query or you want,
Lordship,
you want
the
to
one
put in your written response?
one condition, Lordship, at page 113, I would like to read, Lordship, selection process. It states, Lordship, the selection process shall be as per the relevant provisions of the Assam State Prosecution Service Rule 2023, and date, time, and venue for the selection will be intimated to the shortlisted candidates accordingly.
Mr. Naik.
So it is mentioned there. No,
Mr.
what I'm
Naik,
submitting,
you
Lord.
need to- Look at this. You need to respond to what has been argued. ये सब दिखाएंगे तो कैसे होगा?
Lordship,
not interested in
what I am submitting, pursuant to this advertisement, these petitioners participated, they appeared before the board, and they are unsuccessful.
बड़ा मुश्किल है. You are converting this into a writ petition. But there is a challenge to the rule.
Yes, Lord.
We are not concerned. Therefore, we are not even looking at the advertisement.
Lordship, my submission will be, what is the locus after participating in the interview by following the same procedure that has been laid down?
Is he challenging the appointment made this time?
No,
Then
no, he has
why are you
challenged.
testing the locus? Mr. Naik, please don't waste your energy and don't make us lose our energy. We are on a different issue altogether. Try and understand. It is good to oppose every argument. But if you
No, the selection is under
Mr. Naik,
silence.
make him understand what we are
No.
trying to tell you. Would you like to put
Lordship,
put in
the
your affidavit?
selection is under silence. All
If selection
selected
is under
candidates are
challenge,
parties here.
this right now. Selection is under challenge.
Yes, Lord.
Yes.
Then it goes. No. If selection is under challenge, then
Lord, because
you abandon that, we hear this petition.
which one, my lord?
The advertisement selection, we are not listening to. That goes before the single judge. If you have made that, if you abandon that prayer, we will hear.
People. In that case, liberty must.
We can't give you both, no.
No, my lord, what we'll do,
Uh,
whether that is permissible, I'm just, what I was thinking is, my lord, that so far a challenge to the rule is concerned, naturally it has to be before this particular bench. But regarding the challenge on the other
go before the
infirmities,
single judge.
then liberty may be given, will not praise this here.
You make a prayer, we will allow that.
Yes, yes.
Or the better.
Better lordship takes up in one go, my lord.
No,
We are conceding our right of appeal. We are conceding our right of appeal.
They are not, no.
My lord,
They are not. They want 2 forums. They want 2 forums before single judge and division bench.
no, my lord, it's
You may be wanting, the other side also has to be consulted.
Let them,
And selected candidates will have to be made up. You withdraw this petition.
we have made them party.
What I do is this.
Yes,
You file a separate petition challenging the rules.
okay,
We remit this to the single judge.
okay. Done. In the meantime, just now I got to know Rajasthan, Bihar and so many states, they have written. So we'll annex those and come up with that.
I remember that.
Yes,
I think the better option would be.
yes,
that-
yes.
No, no.
Yes, yes,
The better option would be we are remitting this to the single judge.
yes.
And you file another.
Separate petition assailing the rule. Yes. Oh, yeah.
That's a better way if you're really interested in bringing transparency
Yes, 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 yes.
and change of the rules. This goes before the single judge. Take it.
Only thing is, Milord, by 11, they are proposing to give the appointment. So let's Monday or Friday, Milord.
By this petition, the petitioners have challenged the impugned selection list of additional public prosecutors dated 21/11/2025. Prepared pursuant to a viva voce test against advertisement dated 2/1/2024 for appointment of 26 posts of public prosecutors and 87 posts of additional public prosecutors, 26 posts of public prosecutors, 87 posts of additional public prosecutors, and 181 posts of assistant public prosecutors. Simultaneously, the petitioners have challenged the validity of Rule 19(2) of the Assam State Prosecution Service Rules 2023 insofar as it permits, according to the petitioners, an arbitrary discretion in selecting the candidates only on viva voce test, which defeats the mandate of merit-based selection as professed under the rules in question. Bracket Rule 19, Clause 6. Stop. After some arguments, Mr. Chaudhary, learned senior advocate appearing for the petitioners, agreed to the proposition advanced by the court that these two issues cannot be conflated, as challenge to the select list could be effectively made before a learned single judge. Stop. This writ petition has been posted before a division bench for the reason of the challenge put up to the validity and the correctness of a part of the rule of 2023 under which the appointments are sought to be made. He thus agrees that this petition be remitted to a learned single judge for deliberation over the issue of the correctness of the appointments, the correctness of the preparation of merit list pursuant to an examination, pursuant to a viva voce examination. And the challenge to the rules shall be filed separately if so desired. If so desired. Let this case go out of our list and be placed before the roster bench, roster single bench for the needful. But without the prayer made in this petition, the learned counsel for the Mr. Chaudhary on this case being posted, Mr. Chaudhary, learned senior advocate, on this case being posted before the learned single judge, would delete the prayer with respect to the
Challenge to the rule.
challenge to the rule of 2020. Let this case,
May we pray for Friday, Milord?
let this case be listed before the appropriate bench on, on so and so date.
30.
Deep level.
Lordship, if possible, if it is listed on Monday, Lordship, it will be convenient for us.
Where?
Monday, not on Friday.
Monday.
Second.
Right.
Oh. Monday morning, let it be Friday.
Preferably, we say preferably on Friday, you can.
Friday.
Preferably on Friday. It's not good to fix the roster of the single judge.
Milord,
So we can.
preferably on Friday. Deep.
Okay.
Item 13.
Increase in the retirement age for this. You are not the professor.
No.
You don't have case.
Milord, but the UGC rule says that the professor and principal are both are.
That it is for the government to bring it to the cadre of principal. You are in charge principal, you became a principal. I don't think you have a
No.
case. Dismiss. You never became a professor. How can you stay till 65 years?
Milord, it may not be, but Milord, the qualification and same.
Qualification, salary, everything same. My
No,
qualification and
No,
salary
no,
is same
my
as
lord.
that of.
Milord, this UGC rules are applicable to them, Milord,
What
and
was
they say, Milord, they say.
Our High Court division has decided the issue,
No,
Lordship.
that's true, Milord, that's true.
Same issue,
But-
Lordship, exactly same issue. Lordship.
But Milord, the college principal and professor
By just.
are
All
and Milord, Milord, in another case, Milord, they have,
right, yes.
Milord, in other case, Milord, they have accepted this category, Milord.
Chalo, okay. Yes.
Item 14.
My please, your lordship, my lord, actually, my limited pair is, my lord, actually, appellant is a ballot to a board, my lord, conducting SSLC examination and higher secondary election and self-funded autonomous body. And now we have not received any government grant. Now, my lord, there is a provision in regulation for reimbursement of medical expenditures. And
Just give us a minute.
yes, my lord,
1
response.
minute. Please wait.
Online. Regulation has to put us to 167.
It is autonomous. Mr. Chutia,
My lord,
your grounds do not appeal to us.
my lord, only, my lord,
The only ground which you can say is that you are an autonomous body, not funded by the state. You depend on students' fee,
and also my lord,
lack of government aid, and surgery. Surgery was not to a referral hospital.
subsequently rules were amended, my lord, amended rules.
The operation was undertaken
18.
sometimes in 2016, 2018,
18, my lord.
where 2016 rule applied.
That is our Lalit Siguldas, my lord, held that, my lord, there is no any retrospective effect. That's why, my lord, they say that you have to pay. Now, my lord, if it is minimized, my lord, to 2 lakh rupees, then no problem at all, my lord, otherwise.
Now you have paid 3 lakhs, pay 4 lakhs more. We can't help.
No, otherwise, Lordship may said it was mediation, my lord. Let them say, my lord.
Mediation क्या करेंगे? She is a widow. What not? हाँ हाँ क्या हुआ? जजमेंट कहाँ which page? नहीं पेज कहाँ से शुरू होता है जजमेंट? यहाँ ऊपर में लगा है। Page.
Hey, too. It's perfect.
Yes, we are discussing.
6%.
This case revolves around a dispute over the reimbursement of medical expenses incurred by the late husband of the appellant, late husband of the respondent. For a coronary artery bypass grafting surgery, bracket C. Coronary artery bypass grafting को bracket में लिखना CABG, bracket close surgery. Next pack. The employee, the deceased was a former employee of Board of Secondary Education Assam, bracket SEBA. Who retired as Assistant Controller of Examination / Registrar on October 31, 2005. While still in service, he was diagnosed with heart artery blockage in the year 1996. However, only in the year 2018, after his retirement, he underwent CABG surgery at Vellore, at CMC Vellore, a hospital not on SEBA's referral panel, without prior permission of the board. The cost of surgery came to ₹7 lakhs, and the family of the appellant, family of the respondent, family of the employee sought reimbursement under SEBA's medical attendance rules of 2016, which was in operation when the operation, when the CABG operation was done on the deceased employee, on the employee since deceased, bracket was since deceased. The claim of reimbursement was rejected on the ground that the treatment was obtained in a non-referral hospital the employee left the world of living in the year 2020. his wife / respondent filed a writ petition bracket WPC number 1481 of 2022 seeking reimbursement when the appellant / SIBA was directed to re-examine the claim, verify the same, grant ex post facto approval if needed, and reimburse the expenses, possibly invoking clause 17 of the rules of 2016 for relaxation. Next. Pursuant to the aforementioned directions, the appellant re-examined the issue in a board meeting in the year 2022, re-examined in a board meeting and sanctioned rupees 3 lakhs for reimbursement, applying an amendment to the medical attendance rules 2016, which amendment was made effective from 1st of January 2019, which capped reimbursement at 3 lakhs for ex-employees and their dependents. Dissatisfied, the respondent filed another writ petition before this court, bracket WPC number 7594 of 2023, seeking full reimbursement as per 2016 rules prevailing at the time of surgery. Which prayer was allowed. Next, hence this appeal. Next, Mr. Chutia, no? Mr. Chutia, learned advocate for the appellant, has submitted that there was a reason for making the amendment in the medical attendance rules of 2016, bringing in an overall upper ceiling limit of rupees 3 lakhs for reimbursement of the medical expenses for ex-employees, namely the board being autonomous and funded solely by students' fee. The appellant / board does not get any government aid, and that the learned single judge ought to have considered that the operation was conducted on the employee in a non-referral hospital. Non-referral. This is no ground to interfere with the order impugned, with the judgment impugned in the present appeal, which has only directed for implementation of 2016 rules, which was in operation at the time of the treatment for which full reimbursement is being sought. We therefore endorse the view of the learned single judge and direct for payment of the balance amount of rupees 4 lakhs, while saying balance amount of rupees 4 lakhs, as expeditiously as possible.
Wiping the interest part.
Huh?
Waiving the interest ballot.
Huh. Considering the special circumstances of this case, we are not directing for payment of any interest on the delayed payment of the
Balance.
medical expenses. Delayed payment of the balance amount of rupees 4 lakhs. But when will you pay? Within a period of?
Ballot, I cannot say it, ballot.
Positively within a period of 3 months, 90 days.
Obliged.
The appeal is dismissed.
Item 15.
Nobody appears to business. In fact, several times this. No, he says that don't call me a porter. Nobody appears on behalf of the petitioner. The petition is dismissed for non-prosecution. Same thing. Wait, no.
Item 16.
May I please, your lordship?
The collector has passed an order, no? The CO went there. CO acted beyond. MS Sharma, take instructions. Take instructions and get back to us. If they have not filed necessary documents, they will not have it done. They will not have it executed by the district magistrate. Otherwise, CO is nobody to ask for compounding. Who is CO? Who is the CO? लिखिए MS Sharma लिखिए. The petitioner, a non-banking financial company and creditor of the respondent number. Respondent number? Who is the loanee?
Respondent number. Please.
Respondent number. Respondent number.
Circle
four.
of the three, my lordship.
क्या लिखा है पढ़ो? Respondent number 4 is aggrieved by the fact that despite the order passed by the district magistrate under section 14 of the SARFAESI Act, so year, comma, the authorized CO, bracket respondent number 3, did not take possession, did not facilitate taking of the physical possession of the mortgaged property. MS Sharma to take instructions by the next day, re-notify on 2 weeks, 3 weeks? 2 weeks. Purana flag.
Obliged to. 27-2.
पूरा नाम लिख रहा हूँ.
Item 18.
May I please, your lordship?
Yes.
Lord, this matter may pass over for time being, my lord. The senior.
Time being.
Yes, my lord. The
Why?
senior counsel, my lord, KM Chaudhary, my lord, supposed to argue this matter, my lord.
I will come back after 5 minutes. All right, after 5 minutes.
My lord.
Otherwise, we were about to rise for 5 minutes.
Item 18.
May it please your lordship. My lord, if your lordship should kindly come to page 112.
1 second, let us see our order.
Yes, yes. 2011-25. Book list कौन देता है ना?
Yes.
Yes. My lord, page 112, the order which was under challenge before the Lanit single judge. Whereas an inquiry under Rule 92 of the Assam Services Discipline Appeal Rule had been instituted against Abdul Adut Mullah, AEE.
Stop it 1 minute. Give us 1 minute.
Yes. Huh? Right,
Yes.
Yes. My lord, if your lordship should kindly come to the order passed by your lordship's last two paragraphs, would that then authorize disciplinary authority to, while remanding the matter, change the inquiry officer? And if such a decision is taken, would such an order not partake the character of directing a de novo fresh inquiry akin to the second inquiry? This court prima facie is of the view that in the event of the principles of natural justice not having been followed, the matter was correctly remanded, which remand was upheld by the learned single judge, but whether it was permissible for the inquiry officer to be changed. And if the inquiry officer was changed, what prejudice has been caused to the appellant? Now, my lord, perhaps the question of prejudice may not come once it is violation, it's a violation, my lord. I did not plead prejudice. Now, please come to page 112, my lord, the order which was assailed before the 112, yes. Now, an inquiry was directed, inquiry officer was appointed. Please come to the first subpara. Whereas the appointed inquiry officer Sanjol Kumar Mohanto, the then in charge additional chief engineer, had accordingly conducted an inquiry and submitted a report to the department. Whereas in accordance with the provisions of OM dated so and so, a copy of the said inquiry report had been furnished to the charged officer for submitting his written representation regarding report, if any. Whereas in his written representation, the charged officer has pointed out certain omission and commission on the part of the inquiry officer, which indicate procedural lapses and non-adherence to the relevant rules with proper strictness. So far, so good. Now, this is where, my lord, the error has crept in. Whereas, therefore, for the ends of justice, the governor of Assam considers it necessary to institute a de novo in the inquiry in the matter from the stage of recording evidence, ensuring strict adherence to the proper procedure as per the Assam so-and-so rules. Now, my lord, my submission is, be it an administrative exercise of power and quasi-judicial, my lord, it must be informed by reason. My lord, the disciplinary authority is competent enough to come to a different conclusion.
That's right.
Now, question is, my lord, since I myself has pointed out there are certain infirmities which was acknowledged by the authority, to that extent I cannot have a grievance. But question is whether it should be done by the same inquiry officer or a new inquiry officer can be appointed. Certainly, my lord, going by the preponderance of the judicial view of the apex court, my lord, there is no question of any second inquiry. What is permissible is a further inquiry in an appropriate case. And secondly, my lord, there is no question of changing the inquiry officer. At least in this case, it doesn't warrant. So to that extent, my humble submission is, my lord, the order suffers from the vice of arbitrariness, which the learned single judge failed to. I'll rely on two judgments, my lord, two short judgments.
Dev.
No, my lord.
That's an old one.
That's all. That's the first case. KR Dev. It's a case from Guwahati, my lord. Central Administrative Tribunal's order. Where, my lord, Rule 15 of the CCA rule was interpreted. I'll rely on two judgments, my lord. 2002-10 SCC 471. Two paragraphs, my lord.
This is, what is the name?
Union of India versus KD Pandey.
Sure. Yeah. Sure. कोई तैयारी मत इतना तो कोई तैयारी है ना करो.
Milord will kindly come to page 472. I'll read three paragraphs, short paragraphs, 3, 4, and 5.
No, it's a short judgment.
The proceedings were initiated against respondent number 1 in respect of 6 charges. The inquiry authority in the report made held that none of the charges stood proof. Thereafter, Railway Board, in exercise of the power under Rule 25 of the Railway Servant Discipline Appeal Rule 1968, examined the matter and found that 4 of the 6 charges could be substantially proved beyond doubt with the available documentary evidence, and thereafter remitted the matter for further inquiry as contemplated under Rule 25(1)(c) of the rule. On remit, the inquiry officer made a report finding respondent number 1 guilty of 4 charges. Based on that report, Railway Board dismissed the respondent number 1, which was challenged in the dispute raised by him. The tribunal as well as the High Court are of the view that on the same material, a fresh opinion has been furnished and it was not a case of further inquiry. Indeed, it was not noticed by the disciplinary authority that the inquiry held earlier was bad or that the management of the establishment did not have the proper opportunity to lead evidence or findings were perverse. In absence of the same, it was held that there was no justification on the part of the disciplinary authority to continue fresh inquiry on the same set of charges. Learned counsel for the appellant contended that in this case, the board had examined the material on record and come to the conclusion that 4 of the 6 charges could be proved on the available material, which had not been properly explained in the earlier inquiry. In fact, from the order made by the Railway Board, as well as from the part of the file where inquiry report made earlier is discussed, it is clear that specific findings have been given in respect of each of the charges after discussing the matter. And if that be so, we fail to understand as to how there could have been a remit to the inquiry authority for further inquiry. In this resulted in a second inquiry and not a further inquiry on the same set of charges and the materials on record. If this process is allowed, the inquiries can go on perpetually until the view of the inquiry authority is in accord with the disciplinary authority. My lord, factually, this matter may not be identical to our, my lord, but my lord, the principle of law which emanates from the judgment in my humble submission is, my lord, in an appropriate case, what is permissible is a further inquiry. There's nothing like a second inquiry. That's number 1. And the other judgment, my lord, this is a judgment of 2014, my lord. 2014, 10 SCC 589. On the same line, my lord, I'll read paragraphs 26 to 28, my lord. Please come to page 603. My lord, at para 25, para 12 of K.R. Davis quoted, so I'll not trouble your lordships with that.
1 second, Vijay Shankar Pandey.
Yes.
I have it. Yes, Vijay Shankar Pandey. Which paragraph?
Para 26, 7 and 8, my lord. After quoting K.R. Dev, it can be seen from the above that the normal rule is that there can be only one inquiry. This court has also recognized the possibility of a further inquiry in certain circumstances enumerated therein. The decision, however, makes it clear that the fact that the report submitted by the inquiry authority is not acceptable to the disciplinary authority is not a ground for completely setting aside the inquiry report and ordering a second inquiry. The scheme of Rule 8 of the Discipline Rule and Rule 15 of the CCA rule are similar. Therefore, principles laid down in Dev's case, in our opinion, would squarely apply to the case in hand. Therefore, it becomes necessary for us to examine the legality of the impugned order in the light of so-and-so. So here also, my lord, the same proposition has been laid down that in an appropriate case, They
So
are,
therefore you say that even if there was a remittance,
Ah.
even if not remittance, even if there was a remit, in fact, it should have been from the stage of the vulnerability, not a de novo.
precisely, which was Lordship has indicated, Lordship's earlier order.
The stage of the vulnerability is that examination of witness was not, I mean,
Whatever infirmity was noticed by the
so
disciplinary
that has to be
authority.
stated. No, he doesn't
yes.
say.
Okay.
He doesn't say that.
Ah.
So this is one.
No, Lordship has already recorded that in the earlier order regarding the infirmity.
No, the impugned order.
Huh.
The
Impugned
impugned
order doesn't say.
So therefore, this is no application of mine.
Exactly.
Uh,
That's why I said,
On an
Milord,
application filed by a proceeding, this cannot be done. That's what
Yes.
you suggest.
that's why, Milord, I
And
said,
change of officer. He
Yes.
is not absented. He is not doing. You're not raising any malafide.
No.
Mr. Nayak, the law is otherwise. Now he was the person who was not happy.
Ah.
Mr. Nayak, try and understand this. He was the person who was not happy. Now with the change, it will take time. And with time, his case will have to be considered under seal cover because this will remain
Lordship,
pending.
I am also placing two judgment, Lordship. One is 1999, one SCC 733. Lordship, in this case, Lordship, KRD was
Patika. That's how we remember cases. We can't remember the number.
Union of India and others versus P. Tyagaraja.
They are aware of.
1999, one SCC 733.
Tyagaraja. What does it say?
Lordship, in paragraph 7, Lordship, KRD has been quoted. Paragraph 7. I'm reading paragraph 8. Paragraph 7, KRD has been quoted. And paragraph 8, I'm reading, Lordship. A careful reading of this passage will make it clear that this court notices that if in a particular case where there has been no proper inquiry because of some serious defect, having crept into the inquiry or some important witnesses were not available at the time of the inquiry or were not examined, the disciplinary authority may ask the inquiry officer to record further evidence, but that provision would not enable the disciplinary authority to set aside the previous inquiries on the ground that the report of the inquiry officer does not appeal to the disciplinary authority. In the present case, the basis upon which the disciplinary authority set aside the inquiry is that procedure adopted by the inquiry officer was contrary to the relevant rules and affects the rights of the parties, and not that the report does not appeal to him. When important evidence either to be relied upon by the department or by the delinquent official is sought out, this would not result in any advancement of any justice, but on the other hand, result in a miscarriage thereof. Therefore, we are of the view.
If you're opposing this petition, then this is against you, no?
Lordship, in this case, Lordship, we have not, there is no disagreement with the inquiry report submitted by the earlier inquiry officer. A decision was taken only because of a representation submitted by the petitioner.
That's what the.
That is what.
That's
Now,
what
even if at this stage, the appointment of, the further inquiry is stalled, or the appointment of the next inquiry officer is set aside, we are ready to take action on the basis of the first inquiry report. That is there. That will be there.
Mr. Nayak, can you argue this? You're ready to take action, so what? Now we are testing
Lordship,
the order
in
of
this case,
remittance.
Lordship, an objection was raised by the petitioners that I was not given the opportunity of cross-examination. It was accordingly moved to the judicial
We
department.
understand that, Mr. Nayak. वही तो कह रहा है ना. So I wonder whether you are arguing from this side or that side, because
side.
what you're arguing is all right. It is only in support of what he's saying.
No, in this case, Lordship, court said if the authority is not in disagreement with the inquiry report submitted by the earlier officer, there is no question of setting aside the inquiry report. We have not set aside the inquiry report.
No, that's that is. Oh, but can-
Lordship, what I am
Inquiry
submitting,
report was with which officer? If you're not, anyway, you make your arguments, but please understand what you are talking.
Lordship, there,
You are.
my understanding of
you are
this law is
coming
that.
with correct proposition. Tyagarajan is correct. What Vijay Shankar Pandey says, so the Supreme Court says. in
Last two line of paragraph 8, Lordship, once again will read. Therefore, we are of the view that Rule 27C enables the disciplinary authority to record his findings on a report and to pass an appropriate
What
order,
is the end result?
including order a de novo inquiry.
Mr. Naik, therefore I say that we are supposed to understand whether you are supporting the cause of Mr. Chaudhary or you are opposing it.
No,
If you
in this case,
press-
the
just a
authority,
minute. Try and understand.
Lordship.
See, please don't mind our irritation, but if you repeat same things, it's very difficult, no? If you can pass an order, if you are ready for the report to be acted upon by the disciplinary authority, that means the order passed by the disciplinary authority is superfluous, it's useless. Correct? So don't you support his cause? He just wants that. Now he's not pressing his petition where he said that he was not allowed to cross-examine. He says that you can't change. That's what he's saying. And so you're supporting him, aren't you?
No, so far as second point is concerned, changing of the inquiry officer, Lordship. Lordship, this order was passed in the month of January
You have
2023.
conveniently skipped this point when we are.
No, I'm not
confronting.
skipping. What I'm
The
submitting.
question is
Lordship,
that if you're ready for everything,
Yes.
then this remittance, this order of remand is bad. We've strike it down straight away.
No, I'm not saying that. What I'm saying, Lordship.
Then what are you saying,
Lordship,
sir?
if there are some procedural lapses, in that situation, Lordship, authority may
Anyway,
direct.
we have heard you. Now tell us about the second, if you.
Lordship,
We
so
don't
far
need
as the
to repeat.
second issue is concerned, from the stage of recording evidence, the second portion of the inquiry was ordered. It was on 12th of January 2023. Lordship, what I have recorded notice, Lordship, the first inquiry officer, he retired on 31/8/2022.
He retired.
Yes. So Lordship, on this point, Lordship, I am placing one judgment wherein, Lordship, the Honorable Supreme Court has said.
No, that's right. This is not in our contemplation. He has retired. So another person has to step in or he continues.
Yes.
Unless his tenure is extended.
Yeah. So that proposition is not correct just because the inquiry officer has been changed. It will take
The
form of
order
a second.
facts of this, that because the inquiry officer hurried and he did not cross-examine, he did not put it, he examined such witnesses who are not in the list, therefore change him.
Probably, Lordship,
The
it was
order perhaps smacked of this, but this is doctrine of necessity.
Lordship.
He is retired, so it's all right. So new person.
Lord.
But whether remand is good or not,
Lordship, probably it was the understanding of the authority, Lordship, if it is not done, ultimately he will again challenge the, imposition of penalty before any court, Lordship. In that situation, if court interferes, Lordship, just to avoid that situation, this.
he doesn't want that report. Let us do it. Let the disciplinary authority decide. No second inquiry. Let the disciplinary authority decide on the issue, on the report already filed. He can always differ.
So that report is already there, and there is no.
Therefore, in nutshell, you are only making him happy.
No, he is saying. No, that earlier report also is not in his favor.
Naturally, but he.
And on the basis of that report also, we can impose penalty.
Are we saying that accept the report or don't accept the report? He says that this remand is, today he says remand is bad.
Yes.
It is backed by judgments. This proposition is backed by judgments. Somehow the other, you also support this. So aren't you supporting him?
Lordship, what I'm by submitting.
Supposing the remand itself is rejected, where is the question of appointing another inquiry officer?
No,
If we
what
find
I'm
that
submitting,
everything
Lordship,
you're saying,
if,
why
what
are
I'm
you
submitting,
making you
Lordship,
understand?
one inquiry report is already there. And that inquiry, it is not that that inquiry report is suitable to us or it is in favor of the petitioner. That is not there. On the basis of that report also, Lordship, we can take action against him.
So what is he talking?
Lordship, his objection is that I was not given the opportunity of cross-examination.
What's that objection?
So that was his,
We have followed that. Why can't you? If you enter one part of the river, is it necessary that you remain midstream and you will not come back? He made that question, but he never anticipated that the matter will take so long and there is a remand.
Then Lordship will, what is my apprehension and What
What
is
do you
my understanding?
think?
Lordship will take the second judgment, Lordship.
What do you want us to do?
Lordship, I am reading a
Just
very,
a minute.
Lordship will read.
Just a minute. Desultory argument is not going to fetch you any result. You are arguing question of law, you're showing us the provisions. This is for your benefit also as a lawyer. Forget about your client, state. As a lawyer, when you're making an argument, it should be purposive.
Yes.
So you want us, just a minute. You want us to dismiss this petition or allow this petition? Now tell me this.
I leave it to your Lordship, but before that, Lordship, I want your Lordship to read the second judgment I'm placing, Lord. That probably convey what I'm thinking.
You tell us without.
Lordship, this is
Just a
Lordship.
minute, mister.
Lordship.
You just tell us whether you want us to dismiss this petition or allow it. What pleases you?
Lordship, I do not want a situation where the tomorrow petitioner will again come up before this honorable
Can
court,
it be stopped?
challenging.
Can it be stopped?
At least that lacuna will not remain there, Lordship. That not giving an opportunity of cross-examination.
Anyway, you argue it is.
Lordship,
this.
one second judgment, Lordship, 1995.
And in fact, we would be at a loss to tell ourselves whether you have succeeded or he has succeeded. Otherwise, we are finding this remand to be bad.
Probably this judgment will. 1995, supplementary SCC 592. State of UP, Rabindranath Chaturvedi and another.
Yes. Okay. Yes. It's a two paragraph.
Paragraph 2, yes, Lordship. Paragraph 2. The High Court has set aside the imposition of the penalty on the respondents on the ground that no reasonable opportunity was given to the respondents during the inquiry of the inquiry officer. It is also found that no one was examined to probe the case of the state. It would be desirable that an officer who is acquainted with the record may also be examined to prove the documentary evidence, and opportunity may be given to the respondents to cross-examine the witness or produce any evidence in rebuttal. Thereafter, inquiry will be conducted, the report will be given, and copy thereof will be supplied to the respondent.
We have not followed the relevance of this charge.
Lordship, in this case,
no
Lordship.
Principle of law here, it's only on the facts of that case. Demand को oppose करो. Well, if you're in favor of the remand, Mr. Nayak, you should not have pointed Tyagarajan to us.
In my
Therefore,
understanding,
we asked you, you want this remand or you don't want this remand?
Lordship, in my understanding of Tyagarajan is that if there are defects, there were procedural lapses, then there is no wrong in the authority directing a de novo inquiry.
But without observing, without recording, merely on the basis of what Mr. Chaudhary had given in representation.
Lordship, in all situations, it is not always necessary that the order should reflect everything. Lordship will see the record if it is there or not. It is not always necessary.
Before remand, nothing is required. This is what you have
Lordship,
read.
I have seen some portion of the record, Lordship. I found sufficient material.
Deciding, no, this issue.
Authority decided before.
Neither are we deciding.
No.
Question is that the disciplinary authority, on receipt of the report, has to make an assessment that, well, the application which was filed appears to be correct. These persons were examined on behalf of the management. An employee was not given an opportunity to cross-examine him.
Lordship,
let it go.
Lordship, after receiving the inquiry report, a copy was furnished to the incumbent. He submitted his written submission. Certain objections were taken. Accordingly, a decision was, after taking views from the
Where do we get it?
In the records, these are
in the record.
Yes.
No, it's not required to say. So I say the application allowed. Supreme Court should understand that we have gone through, we have heard you, we have heard him. Correct?
Lordship, that situation, I am placing this judgment only to reply that situation, Lordship.
जो है उसको report करेगा in case he requires it. In case it is, then he must. So we are, to that extent, we are allowing the petition. Mr. Naik, you have not understood. We will say that on the inquiry report, the disciplinary authority shall take a call. If he thinks that no, these witnesses, he may then remand. And in that case, another inquiry officer will have to be appointed for the reason that the other fellow has retired. Finished. So this only takes it further to a point of time. He has to take a call. So that way, he also succeeds without any benefit. He also succeeds.
No,
Question of law should
I can't ask more than that, my lord.
Question of law must not be tinkered with. Correct. So and please don't take this, otherwise you will give us the latitude, Mr. Nayak, that we will allow petitions, we will dismiss petitions without recording our reasons. Can it be done? We have heard so and so, the application stands, the appeal stands allowed to the extent indicated above. Give all the judgment will. मेरे पास बैठे।
Item 19.
Yes.
Lordship, we have filed Wakaratnama for all the respondents in this matter. However, your Lordship, respondent number 112 is not shown in the cause list due to some reason. And also, your Lordship, we have filed our reply in this matter.
Up till now, you have not done that.
No, your Lordship.
Why?
Yesterday, we have filed our reply. It's not in record.
Yesterday, you have filed your reply.
Yes.
We'll have it called.
Okay.
You're ready?
No, your Lordship. Senior.
Who is leading you?
Lordship.
Who is leading you in the matter?
Gaurabjyoti Sharma, Dr. Gaurabjyoti.
Mr.
No, Dr. Gaurabjyoti Sharma.
All the respondents have been served. The reply affidavit also has been filed, but the same is not on record. Let the same be placed on record on the next date. Re-notify on which date?
Any date, Lordship.
Give us a date where both of you would be present. It's an old matter. We will
Yes, Lordship. It
decide.
may be taken up next week, Lordship.
Hmm?
Today only I have received the affidavit in opposition. It may be taken up next week or.
Next week would be too early. March.
Obliged. And interim order may be continued, Lordship.
Huh?
Interim order may be continued. Obliged.
If we are not passing any order, that means it continues.
Lordship.
16 March. Item 22 to 22. To 22.
Yes.
Lord, I appear for the Assam Provident Fund organization, Lord. So there was direction given to the bank to give us our dues, which the bank has duly given it to us.
Okay.
And now only a small component is left, that's a interest component. We have written to the bank, we have to receive their reply.
Who appears for the bank?
But I appear for the bank, well, every time they're coming up with some demand.
No, no, we have
You
recovered,
dispute that.
we have recovered.
See, the whatever.
No, if it is,
them
if it
the
is
pay.
due under the terms of the, I mean, whatever is there, my lord, we'll definitely honor it. But the demands can just come on the eve of
No
this.
more. I mean, because the short component of interest at the rate of what?
Not interest, my lord, interest. we have paid.
My
I
lord,
think what they're charging is, I think, some insurance claim. Huh? Insurance.
They are not charging it for themselves.
if your lordship peruses page
Yeah.
61
Let-
of their
please.
affidavit,
So you pay that.
2,80,000.
Okay, we'll pay, my lord. Let's we'll close this, my lord.
We'll close it. Pay that.
2 lakhs and odd. we'll
Yes,
pay.
yes.
Well, without going into the marriage subject, we'll pay.
Take that. We have heard
J. Bora.
so and so for the petitioner and so for the. This writ petition was filed.
22.
This writ petition has been filed by the Assam Chief Employees Provident Fund Organization a statutory body under the Assam Tea Plantations Provident Fund and bracket and Pension Fund bracket close and Deposit Linked Insurance Fund Scheme Act 1955, hereafter to be referred to as 1955 Act of 1955, challenging the e-auction sale notice issued by the respondent Union Bank of India on 13th of October 2023 for the Boracay Tea Estate, which had become a chronic defaulter, owing rupees 1.66 crores in Provident Fund dues, gratuity, deposit linked insurance, administrative costs, and interests. The next paragraph. The 1955 Act mandates 12% contribution from both employers and employees whose wages are up to 15,000 per month to provide social security for tea workers in Assam's plantations. The petitioner / organization managed by a board of trustees claims a statutory first charge under section 10 bracket 2 of the 1955 Act over the state's assets for the dues of the workers, which they say, which they claim, which they insist for being paid in priority to all other debts, including bank mortgages, due to the non-authentic clause overriding other laws. To state the facts in short, Boracay Tea Estate, bracket respondent number 4, owned by respondent number 5, defaulted on loans to UBI, bracket respondents number 2 and 3, whereupon the SARFAESI Act 2002 was invoked for taking symbolic possession and auction the estate with a reserve price of 9.91 crore.
Delayed deposit of DLL.
Since the petitioner's organization was never notified
165.19.
of the possession or auction,
Yeah, 12,165.
which they learned only through a newspaper notice sometimes in October 2023. They have challenged such auction sale, claiming their first charge on the sale proceeds. On the sale proceeds. Today, Mr. So-and-so learned advocate from the petitioner submits that whatever was due to the organization has now been paid by the respondent. By the respondent number?
2 and 3
Respondents number 2 and 3.
and 8 also, my lord.
Respondents number 2, 3, and 8. And only a small amount is left to be paid, which is towards the insurance claims of the worker. Mr. Ken Chaudhary, learned senior advocate, appearing for response number 2 and 3, submits that the aforementioned claim shall be paid to the petitioner within a period of 4 weeks. With the aforementioned
4 weeks, 2 weeks, my lord.
when the aforementioned 2 weeks, with the aforementioned assurance given by the petitioner, given by Mr. Chaudhary for response number 2 and 3, the petitioner organization does not press this petition any further.
Let's quantify the amount. It is 2 lakhs,
Small amount.
80,000,
2,80,000,
86,
86.43.
0.43.
Bracket में करना. The grievance of the petitioner stands fully redressed.
That by virtue of the interim order, my lord, we were debarred from issuing the sale certificate, or that interim order
The embargo on issuance of sale certificate
is lifted.
is thus lifted.
Item 22, my lord, is a writ petition that I have filed on behalf of the union, which is also connected. The fact remains is I have also challenged the e-auction on the ground that my dues, which are the labor dues, are still pending. And your lordship has said on the last occasion that the protection that was to be given to me is not required in the present case, because 6583, in which your lordship has just now passed an order, the protection where the money is not to be dispersed is also protection to me. Now, if that protection goes, my lord, then my writ petition will have to be.
What do we do?
My lord, that has to be heard, because in that case.
No, we'll hear it.
Yes, ma'am. That's all I'm saying, because that will have an impact on my petition, ma'am.
Will he?
Yes, ma'am.
So this remains pending.
Yes.
Yes.
You please argue it. This is over. Yes.
Item 20, 21. No, there is another item 21. 21, my lord.
There's another item 21.
This is 22.
I'm 22, my lord.
21, we have passed the order, but we will keep it pending till the time we hear his petition.
No, 20 was passed.
I'm 22, my lord.
We have passed this order in 20.
20.
What happens in 21?
No, 21 similar, different garden, but there is a stay order. Our stand is if the bank is allowed to go for auction, or we recognizing each other's dues, we don't have any
Your
problem.
lordship, same as the order passed in this 20 number item dated 12 to 2020.
You are paid.
No.
Your
There's a
shall
stay.
pay.
There's a stay in this case.
We will
There's a
sell,
stay.
and after that we will again.
My lord, in item,
Alag करते हैं. So 21, I think we can pass necessary order with the assurance that every claim 12% of that, I mean, first charge would be paid.
No. Your lordship, just kindly, your lordship, that 12 to 20.
my lord, in item 20, if your lordship
Same order may
peruses
be passed, your lordship, in 2021.
In the earlier proceeding, there is an order on
12
12 to 20.
12
12
to
to
25.
25,
There's an order of India.
where the stay was lifted, saying that you consider dues.
Item 21 is what? Oh, yeah, it's same order. No, they are. Yeah. Yes, mister, same order.
Same order, your lordship, 12 to 20.
Correct.
We have
So,
already.
but here the payments have been made
Hmm.
in 20. In item number 21, you have to make payments.
And we are yet to assess how much we owe.
Yes, they will say us, they will
Yes,
be
yes.
doing the sale notice.
Yes.
All right. So number 22 also with the necessary changes.
21.
21.
21.
21, your lord.
That's right, 21. 22, we will hear it.
Yes.
In this case, they have been protected by the petitioner, because when there was a queue, we have a rent agreement with the petitioner that we've been running. So my interest is protected.
No, look at this. Your protection continues. It is only for protecting you that we have protected him, and therefore he succeeds.
Fine.
So all other things are dependent. Yes.
Yes, ma'am.
And who are you?
I appear for the union, my lord, the trade union, yes, which was under the erstwhile ownership, my lord. There was a due that was registered. And in fact, your lordships, in the last date,
No, you'll have to go in litigation. We will not do it. Now, what about the union?
What is their locus? What is the amount? due?
Union. What is the amount?
My
Have they
lord,
come?
that was a case where, my lord, how can union have a separate cause, my lord? Dues were there, dues have been paid.
no, this due
Let them
arises.
clever court, my lord. Let them raise a dispute.
Not quantified. That is their protect.
And my lord, what is their due? They must quantify. No, ये तो केस तो बड़ी बढ़िया है ना, हम तो सब करबो मारी ना।
Based on the submission for the garden unit, Maratha labor member. This is a protection call.
You have to respond to their
Yes.
demands.
Correct. Whether it is doable, not doable, nothing has
No,
been
no,
said,
no,
my lord,
we'll-
because it
we'll
has to be
respond.
certain to a certain extent.
Okay. Mr. The item number 21,
22, my.
we have dictated. 20, just 21 dictated, 22 will go before the single bench.
Yes. With the protection, because my lord, otherwise, the 20 and 21 that your lordships have disposed of, that interim protection will go, my lord, because
No.
your lordships has said 20th of August is what has been said.
You can recover it from them, no? You can always recover it from them.
If they succeed.
If-
quantified. But will it no quantification?
If you succeed before the learned single judge, get an order. I mean, get an order against them. But we can't, keep you tagged. You have a different locus, different cause.
Surfacing matter, my lord, and the dues has to be first said with lordship.
See, your challenge to the sale notice, etc.
Yes,
That
my
we
lord.
have decided in the earlier part.
Right.
Now, what remains is prayer 4.
Yes, my lord.
Prayer 4, that can be decided subject to their admission, rejection, whether it can be decided by report or by a labor court. That will
Correct.
depend on the.
Also with the fact that I have challenged the e-auction, my lord. My challenge is also the
Just a
e-auction, my lord.
minute, we are not.
I have
remitting
challenged
it
the
now.
e-auction also, my lord.
We are not remitting. Mr. Hogan, listen to
sorry.
us.
I'm sorry.
We are concerned about you.
Yes, my lord.
We are not remitting it to single judge because there you will be immediately thrown out saying that this is a surfacey matter, go before the
Correct.
correct authority. Since we have heard them, we are keeping it here.
Okay, no problem. I'll be.
No problem. We'll file our
Let them at
response.
least file a response, my lord.
Number 22 may let response affidavit be filed on behalf of response numbers.
2 and 3.
2 and 3, my lord.
2 and 3.
Today, respond number 8 has filed a response, my lord, who was the
and
auction
3.
purchaser. Yes.
2 my lord, bank is 2 only.
2. So, 21 में लिख के 21 हमें दिखाओ, हम उसको correction कर देंगे, then take it to brother, he will do 22. And 23 right that. Confused है, पता.
Okay. Number 20, 21 and 22. Okay. 63. Item 23.
In item 20, my lord, I am praying for a little accommodation for today, my lord.
But we have some urgency. We have been waiting with a lot of
I
expectation.
think Advocate General is to appear in this matter.
Yes, that is why, my lord.
If a short date,
Short date
today,
will
for
be-
today, I am not opposing, but any short date.
As paid for on behalf of the learned Advocate General. Let this matter come up as when.
Can it be on 6th? Mo?
Sorry, take nothing. 8 तारीख को भी जाते हैं, November.
In that case, 11th, my lord, if it is not me.
6th of February, he is not here till 13th. Again, it will be adjourned. So
Right.
take a date where
In that case, 16th.
16th. 16th of February.
Yes, ma'am. Obliged.
24 and 25.
My lord, here in this case, my lord, I have filed a affidavit in reply, lordship, to the affidavit in opposition to the respondent number 5, lordship. But that is not on record, lordship. So, lordship, kindly next week, lordship, along with my
Rejoinder affidavit
rejoinder.
is not on record. Let the same be on record on the next date. Re-notify on March.
My lord, kindly can it be on
March.
all right.
12 March.
Very good.
Item 26.
Issues, lordship, in a narrow campus, your lordship. This is a
Narrow
case-
compass.
Lordship, let's say the issue, your lordship, this is a matter relates to appointment of Anganwadi worker, your lordship. In fact, your lordship,
Just give us a minute.
lordship.
Who appears for respondent number 6? You want to respond?
Yes, my lord.
You're ready?
Yes, my lord.
Ready today?
Ready, my lord.
All right. Pages of sixteen. Yes.
Lordship. Here, your lordship, only question is this, your lordship, the guideline which has been framed by the state government.
There's no difficulty. But
Lordship.
who, guidelines are all right.
Lordship.
Majority population.
Yes, your
But
lordship.
who decides?
Now, your
Selection
lordship,
committee.
no, your lordship, it is an admitted position that 40%.
Who admits? Mr.
No, your lordship, this is admitted by file, by them, your lordship, as
Where is the notification of the department
regarding that for more than 40%, your lordship.
regarding reservation of the category, the center?
No,
as,
your lordship will
reserved?
kindly see here, your lordship, it is a fact, your lordship, that the advertisement did not mention about that, although as per the guideline, it should be mentioned, number one, your lordship. But at the same time, it is also a fact that the guideline which has been framed by the state government, because there is no rule otherwise for this recruitment process, your lordship. Now, these guidelines says that more than 40% and above, then it will be by the
Whose statistics, whose reports?
no,
are
your
we to
lordship will
rely?
kindly say that subsequently when the affidavit has been filed and that has not been denied by them. Also, your lordship will kindly see it is admitted by the authority, it is admitted by the writ petitioner that yes, it is more than because he has not denied it. He has not denied it that there is more than 40%.
Such
Now
matters, Anganwadi center, Anganwadi workers, we are not going to insist. I mean, doctrine of non-traverse will not apply here. I mean, we have to be practical about it. Where is the notification?
Now, your lordship,
And
will-
otherwise, how can that be done if the advertisement does not say that?
Now
Why
you-
should other appear?
no, your lordship may kindly come to the guideline for a moment, your lordship.
Guidelines we have read.
Yes, your page
It is
106,
there.
lordship.
Guideline says that the
That, yes,
preparation
your lord.
given to more than 40%.
And your lordship will kindly see in the same
We
guideline,
have no quarrel with the
The-
guidelines.
lordship.
We are only asking you, where is the notification of the center being dominantly populated by the SC?
No, your lordship, that what they have not mentioned in the advertisement, that is an admitted position. I can't deny that.
Therefore, the higher scorer has.
No,
way.
your lordship will kindly see, the point is what I am submitting, your lordship. It is not, at best, it is a case for your lordship remanding the matter
Once
to
it
the
was
authorities for fresh advertisement. Because your lordship, by doing that, your lordship, what they have done, your lordship, that this particular SC community, we should get
Let's see
your
what's
lordship.
the stand of the state. State, they would like to have this order sustained. What is your stand?
The affidavit
Because
says,
you are the mouthpiece, you represent the communities. Therefore, you
Well,
will be
the-
taking a stand.
I can only submit on the strength of the affidavit that is before me. That says that he was earlier appointed because of that 40% thing. But pursuant to the order of the Honorable Single Judge, respondent number 6 has been appointed. That's
Is saying that the entire advertisement was wrong. It should have been notified because this is the guidelines. You heard Mr.
Yes.
Thakur's argument.
yes.
What do you have to say to that?
The advertisement is not under challenge, my lord, in the prayer.
It is not under challenge. He says that this order, in fact, it should have been remanded. The challenge is something else. The challenge is the respondent number 6 being appointed. Direction for her appointment.
Yes.
He does not question that she is a better candidate. So far as marks are concerned, she has scored more, way ahead. But she has, Mr. Botakur, because he hails from a community which has to have a preference where more than 40% of the population is of that community in an area, in an Anganwadi center. In fact, that is his claim. So he says that it was wrongly not notified, but this statement that more than 40% is SC population there in that center has not been disputed.
Yes, but that is there. That's it. That's it. Deny consent.
Now, your lordship will kindly see, there is a purpose for which your lordship this.
Appears kariye na, this is important. It's not a question of Mr. Botakur or him. It's a question that the Anganwadi center remains a non-reserved center. Therefore, important issues are likely to come up.
Yes, my lord.
And your statistics, of course, of 2019 or of which year? 2019,
2018 April, your lordship.
2018 April.
April.
That statistic shows that it is predominantly SC dominated.
Yeah.
Correct. So this is your guideline, and you are not saying anything. The state has to intervene here.
Well, the notification also, well, the governor's notification also says that, my lord.
It's a good. You possibly you cannot support him. You can't. Now that the issue has been raised, you can't support him. Otherwise, you will be going beyond your policy decision.
Yes, that well, it is as it stands, my lord.
As it stands is difficult. See, the whole responsibility we are going to put it on you. We'll say that the reasoning given by the learned single judge is correct. That also, when the state has no objection to it, it is you, the state has come up with the guidelines, no?
Yes, my lord. It's
So
the guidelines of the
therefore
state.
you give a go by to the guidelines.
At the time of the advertisement, yes. That is evident.
Take a call because it will have far-reaching consequences.
Indeed.
That's why he's seeking a remand,
Lord.
not saying that the selection with nothing. Because all time to come in future, he will remain as a general. He knows that, take a stand. He knows that he has not scored well. Correct. So he's relying on your guidelines. You are supporting him.
Difficulties,
So therefore he
the
wants a remand.
advertisement stands.
So
The
on remand,
advertisement.
have your instruction.
I will have my instructions.
Take instructions from the government Department of Panchayat. What is this?
Social welfare.
Department of Social Welfare. Take a stand. Otherwise, it shall be. Even then, the result would be probably the same because it was not advertised.
It was.
But henceforth, it should not be like this. Yes. Again. A piquant situation has arisen in this case. The dispute basically is over the appointment of an Anganwadi worker at Purani Kalitapara Anganwadi Center under Dudhnoi ICTS project in Assam. The appellant, who hails from scheduled caste community, was selected and appointed as an Anganwadi center, as an Anganwadi worker in the said center in the year 2019, which selection was based on the government guidelines giving preference to such candidates who hail from the majority community of this majority community of the center. The majority of the population in the center is of scheduled caste. However, when the post was advertised, the center was not declared to be a SC dominated center. Thus, the appointment of the appellant was challenged by respondent number 6, a candidate hailing from the general category who had scored way higher than the appellant. The claim of respondent number 6 was endorsed by a bench of this court, leading to a remand of the matter for fresh consideration with respect to the candidature of the appellant and the respondent. Later, the learned single judge who had heard the matter directed for the appointment of respondent number 6 on the post, on the position, not post, on the position, which has led the appellant to file the present appeal. The sole contention of the appellant is that according to the government guidelines, such centers with majority population of SC should only have a SC Anganwadi worker. However, the predominance of the SC in the area has not been notified except for a census of the year 2019, disclosing that more than 40% of the population attached to the center hail from SC community. The selection of the appellant, however, was made after the selection committee of itself considered the center to be the center to be falling in an area which was inhabited predominantly by members of the SC community. The learned single judge in this instance, the learned single judge therefore found that selection committee had no authority to declare a particular center reserved for a particular community, which power was exclusively in the domain of the Department of Social Welfare through the CDPO. Stop. Apart from this, even the statistics with respect to the demographic composition of the area attached to the center was of 2019, whereas was of 2021, whereas the recruitment in question is of the year 2019, which is prior to the census about which the appellant has been talking about. The appellant about which which is the basis, which is the sheet anchor of the argument of the appellant. Full stop. The state ought to clear its stand whether awaiting the stand of the state to be clear, awaiting the clear stand of the state in the matter. The case is adjourned to 2 weeks.
3 weeks subject to conditions of the fund.
Who is officiating?
She was already appointed.
Rightly,
Your Lordship.
she is a higher scorer.
No, that's true, Your Lordship. But my concern is different, Your Lordship.
But then this is for future. You shall not be disturbed. But for future, they must clarify, no?
And in fact,
Otherwise, every time this litigation will keep coming.
and this guideline, Your Lordship, Supreme Court says,
Mr. Thakur,
these are mandatory.
you
Your
have challenged the advertisement also.
No, Your Lordship, I have not, since Your Lordship, I have been allowed to participate, appointed. Where is the question of my challenging that, Your Lordship?
You should have challenged it to the extent that, well, the selection would be from a bigger pool. It would be advantageous for you if the pool is shorter.
Your Lordship, that's.
So you should have challenged that.
Obliged.
20th February, 20. Item 27.
Yeah. Who appears for the state?
We have filed our reply, Lord. Today I received one copy from their side.
Yes, we have filed our opinion reply to them.
Rejoinder.
Yes.
Yes.
Okay. The rejoinder affidavit has been served upon Mr. Nayak, learned government additional, Mr. Additional Advocate General only today. Let this matter come up for consideration on your date after 2 weeks, 3 weeks. Look at this, Mr. Nayak. Legally, you may be right. Strictly speak. But here we would not like to exercise that jurisdiction. It was because of the fault of the employer that
I'm not agree, Lord.
Huh?
That is what I have clarified in my.
You clarified. See,
Lordship, in fact, Lordship, even after Umadevi, Lordship.
Parallel which has been drawn of that case. What is that Upen Das system? That's different. Upen was a temporary employee.
Lord,
He's a work charge employee.
he is also worker. In that case also, Lordship, master all workers all were there.
Yeah. Now, you see, look at this. Work charge we all understand. But there are two full bench judgments. We don't want to bring it here. of Jharkhand and of Patna High Court, where they say that this, you can't make any distinction so far as payment of post-retirement dues are concerned. And it was not interfered with, notwithstanding the judgment in Jaswant Singh, the first of its case of regarding work caste capital. Can you have a look at it? ऐसा करना was way back. Mobina Khatun versus State of Bihar. Mobina Khatun versus State of Bihar is a full bench judge, authored by me. तो वो डालोगे तो निकल जाएगा. What's that? निकालो. Mobina Khatun was बहुत. In fact, it was a kind of legislation, and the government agreed with. They came out with her notification. There we have also discussed the principles of equity. Equity begins where law ends. Here the law had not ended. It was in a twilight stage, but still we pressed equity.
But we in
There are
Assam,
two things.
Lordship.
One is America. Mobina Khatun, I think, that full bench judgment. बहुत निकाल के देना. When do we keep it?
February, Lordship.
See, her husband has worked for 36 years and nothing you're paying. Merely because because of some administrative lapse, his name did not find mention, and he died.
That is what I'm, Lordship, trying to clarify, Lord. In 2005, Lordship, we regularized around 30,000.
That's it.
Remaining numbers, more or less same, Lordship. Around 30,000. More or less same. Lordship, even after 2005, we had a policy of regularizing.
You appreciate one thing. What is bothering us is this. You don't deny that her husband had worked for 35 years. You don't deny that. You also don't deny that you regularized 8,000 people.
30,000.
30,000.
2005.
And he was way high in the list. So there was definitely
He
some.
was not there, Lordship. He was not there in the list. Lists were forwarded by the concerned divisions. Accordingly.
But you never dispute this fact that it was a mistake. Therefore, you started the process all over again. But in the meantime, he died,
Lordship,
and you abandoned
in
it.
the next round, Lordship, in 2006, we issued another notification for consideration of the left out master role and workers employee. In the meantime, Lordship, Uma Devi came.
Do you dispute that her husband worked?
Yes, he was working.
You know, देखते हैं what we can do. Here, basic legalism would not govern our thinking.
In fact, I would like to place 2-3 judgments passed by our.
Your High Court, but full bench has some persuasive value. We'll talk about that. We'll talk about Supreme Court judgment.
All those judgments were passed by the division bench of our High Court on the basis of judgments passed by the Supreme Court.
That full bench is also based on Supreme Court judgment, and Supreme Court has affirmed it. The state has accepted it as a proposition of law. The state has formulated a rule completely, embodying the entire suggestion.
Lordship will hear this matter, but my only understanding.
We are not deciding the matter, but
yes,
we are only telling you our tentative mindset.
Lordship, I will definitely like to go through that judgment. I will go.
That judgment may not exactly apply, but we'll take the logic from there.
But there are judgments till 24, Lordship, passed by the Supreme Court. If your services were not regularized, so
देखिए Mobina Khatun पहले देखिए.
I would like to go.
All right, after 3 weeks.
All right.
Let's go there. हो गया? हाँ?
Supplementary list, item 35.
30? 35, yeah. Yes,
Lordship, I am appearing as a petitioner in person in this case.
he had mentioned.
26. 26.
So it is not special, it is SR, not sir.
Yes, sir.
Respond to this petition.
Lord, sir.
You are appearing for,
I am appearing for the election commission, Lord.
you are appearing for?
Election commission of
No.
India. Lord.
State, the elected commission.
Election-
Anyway, respond to it.
Lord, sir. Lord, sir, I would like to submit, Lord, sir. In this petition, petitioners told the petition that they filed, their entire for information, they are relying on certain newspaper clippings, Lord, sir.
Respond to this petition.
Lord,
We are not even issuing
Lord,
notice. to
yes, Lord, sir. Yes.
No, one
In
thing
the
is,
initial stage, if we consider it to be worth hearing, we'll do that.
Lord,
Lordship,
I
this,
don't know, what is he talking about, Form 7? Please, annex Form 7 and then.
yes,
Just
Form
yes, yes,
7,
yes, yes, Form 7, as regards deletion of name, Lordship. They are submitting.
I think if you put it in black and white, it'll be better instead of addressing it as
I'll put in, Lord.
Form 7 is a part of the book, the people's representation.
Mr. So-and-so, give your name.
AI Ali, Lord.
Mr. So-and-so, Learned Counsel for the Election Commission of India. Submits that he shall respond to the petition by the next date. Re-notify 4 weeks.
Obliged.
Lordship, may I submit one thing? Lordship, the hearing process is going on and it will come
3 weeks.
then the Lordship,
We are not going to do anything with that exercise, which to a great extent, it has been approved by the Supreme Court with
no, I
minor
am Lordship, that
modifications.
is why I just 1 minute, I may be allowed to submit.
Let's see, let's
I'm not
have the
challenging
response. of the
anything.
election.
Respond on next day, Lord.
We are not passing any interim order in this, please.
Obliged.
Yes.
24th February.
Otherwise, if you take 1 minute, then we decided in 5 minutes that it is based on paper clippings and therefore nothing. This PIL is not worthy of our attention. You want that? We will hear you.
No, Lordship, I'm just on the legal issue. That is why I.
Forget about legal issue. We will not hear it. We will say that it is based on newspaper reports dismissed. Otherwise,
My lord, at that last
let
day,
the,
my lord, they have come.
let the response come, then we will see.
Lordship.
Don't insist for something which we are not inclined to.
Obliged.
Item 36.
ये यहाँ supplementary कर दो. नीला दंडे का. Yeah.
A small note I have made, my lord, so that your Lordship find it convenient, my lord. 1 page, not even 1.
Yes, on the page 49, the office memorandum, on the basis of which they were appointed.
Page
Promoted, 49. This is the office memorandum 1999. And it says from the below, my lord. Representation for promotion to the post of LD assistant come often received from the grade 4 employees of different offices and this commissionerate is clarified for the benefit of all heads of offices under this commissionerate that they themselves have to dispose of such representation and the commissioner of taxes can know. There is no service rules for establishment of the subordinate offices under this commissionerate. The Assam Ministerial District Establishment Service Rules is generally followed by the subordinate office for the guidelines wherever necessary. According to the provisions of clause B of sub-rule 6 of rule 6, aforesaid rules as amended by government notification dated so and so 10% of the vacancies of LD assistant in the year is to be filled up by selection on the basis of seniority cum merit from amongst the grade 4 staff of the establishment concerned who have passed the HSLC or equivalent examinations and have rendered at least 7 years of service, continuous service, on the first day of the year in which this selection is made. The head officers are advised to take actions on the following. On the basis of this office memorandum, the appellant was promoted. Many others were also promoted. I have given the page numbers of page 56, 221, 221, 221, and 220. So the rule which has been spoken about is at page 68, which is quoted now, right? On the basis of which the first writ petition was dismissed. Page 68, rule 6 of rule 67. Ministerial service. Your lordship will kindly see B, page 69. Who have passed degree examination. By selection on the basis of seniority cum merit from amongst grade 4 staff of the district establishment concerned who have passed the degree examination. So that is the requirement of the rules.
That's all right. Then
thereafter, page 140, review petition.
Page 140.
Yes, the connecting part. The judgment which was passed, relevant portion. Otherwise, the facts which I have given in the note, the notes are there in the judgment. And the basis of the setting aside of the judgment is this.
Mr. Das, prima facie, whether it helps you or it doesn't help you, the proposition of law stated in paragraph 14 is absolutely wrong.
So that it helps me.
It is absolutely wrong, which is not giving you any advantage.
No,
It's something
because
else.
On the basis.
Just a minute. We are on a legal issue, Mr. Das. Please understand. Seniority cum merit, the interpretation in Srivastav's case, Ranjan Kumar Srivastav, by Justice Ravindran, quoting something from Sivaya, if I remember correctly. Is it correct, Mr. Gogoi? I don't know. I have not seen your judgments, but
I have one judgment, my lord.
that is the locus classicus is
Yes,
Ranjan Srivastav.
Yes. It is of 2021, 17 SCC.
That's locus classicus. It is based on decision of Sivaya. Just see if Sivaya is referred there.
Yes, well, that is the paragraph that has been quoted, my lord. I have
So
referred that.
here, the proposition of law is that if it is seniority cum merit, if people cross the threshold of merit
Yes.
and both the persons are above the merit threshold, then senior person will be appointed. Here they say that seniority, first senior and then merit. How can that be possible?
So on that basis, this appellant's appointment was set aside.
Cannot be now.
So this is-
Look at this.
so
Look
This
at this.
proposition is not correct, my lord.
Proposition may not be correct,
Yeah.
but it doesn't help you for the reason that, was there any examination held?
No,
No, nothing. So therefore it is seniority.
no, on the basis of what they have done, I don't know, because the writ petition was hard without.
So
was
seniority
disposed
cum
of without
merit
giving
is,
opportunity to
suppose
the
both of you were considered, you and respondent number one, no?
Yes.
Respondent number one, both of you were considered on the basis of your past performance, 7 years continuous service.
No, we don't know on what.
You
basis
might
it was-
not be knowing, but both of you cross the threshold, correct? And then respondent number one is senior.
Yes, sir,
His
my lord,
services,
merit, how they have, that merit they have.
you have said, sir. In your note, you have said so.
Merit only on the
Merit
seniority.
is, if there is no examination, then it is assessment, overall assessment.
Though, whether they have done it or not, I don't know, my lord, because the writ petition was disposed of
don't know,
without hearing. my lord.
Then if you don't know, then you can't challenge the judgment
No, it was, writ petition was disposed of without hearing me, my lord.
without hearing you.
Yes,
Uh,
because
that's-
review,
So therefore, we are hearing you now.
yes. So then in that case, they will have to give something on what basis they have appointed.
Where have you put that question?
We had stated, my lord, in the writ appeal that it was now, we are not heard.
No, you have not heard, we are hearing you.
In that case, my lord, the record will have to be produced by then, your lordship.
We'll have
satisfied.
records, the records are here.
They say, my lord,
Records are here, Mr. Das.
Yes, your
You
lordship, can you
insisted
see-
that no further time, the matter is urgent, even one day, therefore we called Mr. Gogoi.
Yes.
Please come. You should have checked up the record. We are prepared. You tell us, you argue. And don't go and don't complain again that you are not heard. We are hearing you.
No, that's not actually, but because, my lord, your review petition was allowed, and on the same.
All
day, writ
records are
petition
here,
was
whichever
disposed of.
document you want,
We are not even allowed to see, my lord.
Where has he raised that question?
What?
We are hearing.
Page 135 of the order, my lord. Name is recorded.
Name is recorded.
MP Sharma Learned Counsel appearing on behalf of respondent five.
But on the same
Somebody
day, my
was
lord,
there, man.
the review
Representative.
petition.
Every
review
day,
petition
today,
was-
5 or 6 matters, we have decided it on the first day.
That is all, my lord, your lordship will kindly see on what basis the selection has been done. I don't even know, my lord.
ये सब वही 329 वाला मैटर वही चलिए बहस करिए conclude your
The
argument.
proposition which has been allowed.
Proposition is wrong. We apply the correct proposition. We will say that the proposition is wrong.
Wrong, then therefore, my lord, they
But then
merit
the
how
net,
they have accumulated.
the net result would be this,
My lord, I leave it.
that if they cross the threshold stays, seniority, and otherwise both of you have been considered. So we'll say that both of you have been considered on merit. And then seniority. How have you selected merit?
My lord, it is seniority का merit, but my lord, in merit, my lord, we have considered the ACR, annual
So
confidence.
he has also been considered.
Yes, all has been. My lord, we have relied upon those reports only, man.
So if the merit has been considered, so accordingly, I was promoted, my lord.
That was found to
I
be
was
wrong.
promoted.
No?
my lord.
That was wrong.
If your
You were-
lordship says, my lord.
You were promoted how? You went before the single judge.
No,
and
I
said-
did not go, man.
The-
The respondent number one went.
You were
My
promoted
promotion was second.
considering that you had entered the service as a permanent employee,
Yes.
as a regular employee. He entered as, temporary employee whose services.
No, my lord, he's also regular, mine is also regular.
Oh, his services were regularized from 94. You joined 94.
95. With effect from 1794.
Okay.
Yes.
95 regularized, and you were, you joined grade 4.
98.
98.
Services of both were confirmed on 3/11/23.
Confirmation means nothing.
There's nothing, that I understand.
Joining.
I'm just putting the facts.
नहीं कुछ.
And, my lord,
बहस करिए जो भी बहस करना हो, we are through with the matter.
my lord, we are promoted, this appellant was promoted in
Wrongly.
the year 2018.
Wrongly, wrong. See, can there be any dispute that respondent number 1 is senior to you? Notice.
He's senior to me.
And merit, they have evaluated the.
If they have evaluated the merit, on that basis, I was promoted. I was promoted because if they have evaluated on merit, that's how I was promoted. The question of that only on seniority come merit.
Otherwise also that would be wrong. Seniority come merit means that merit assumes secondary consideration. Everybody must have that basic threshold merit. But senior person, even though less meritorious than the junior, will get the passage.
That's all,
the
but merit,
read
they
that
will
paragraph, Mr.
evaluate.
Gogoi.
Well, I'm giving one
Please read the
judgment. Dear
paragraph
Lordship,
of that judgment, which is very, very instructive. One paragraph.
Read it. Hello, I've given one judgment, my lord.
Which can, that is the
Rajendra Kumar Srivastava case.
Ranjan
No,
Kumar,
no,
sir.
no.
The
Savai, yes.
Same. judge.
Para 10, my lord.
9, 10.
18 says, my lord, we thus arrive at the conclusion that the criterion of seniority cum merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made.
So evaluation has to be done as regard merit first, my lord. Then if you, the
So
both have,
therefore, you are not understanding, sir, that you are not winning this case. That's something different. But
no.
you can, Mr. Das, you are a senior advocate. You would understand what we are hinting at.
Your Lordship is saying something different, my lord, I accept it, my lord.
No, I'm not saying different. We are only telling you what we understand and what the precedents tell us
Yes.
how to understand seniority come merit. Now, seniority is important here, not merit come seniority, but seniority come merit. And class 4, we only consider seniority come merit. It's across the board that this principle is followed.
More experience.
Huh?
Your Lordship is more experienced in administrative side, my lord.
The experience here doesn't matter. The judges who have expostulated, those who have postulated these points, they were more experienced. We only go by precedents. Now here, you were also considered. Respond number 1 also was considered.
So I was promoted, my lord.
You may have been promoted, but wrongly known. So see, if ACR, even if your ACR is better than respond number 1, respond number 1 does not fall short of the minimum standard, then he has his way because he's senior.
Senior, yes.
That is the consideration. Here the merit score is not taken into consideration. He just has to pass. Like in pass course,
No, I
honors
understand that.
marks is
Merit,
added.
how they have evaluated it.
That's what he says. That evaluation by merit.
And even if,
And if there is no evaluation of merit, that means it is accepted that all of you are meritorious. So senior one gets the take. Anything else, sir?
well, in that case, my lord,
Like Ranjan Kumar Srivastava.
That is quoted in para 14. Well, this is the book then. 1998.
my lord, in that case, your Lordship is directing them to re-evaluate it.
That will not be appropriate.
Because court has directed, even
That direction is already there, my lord, by the land and we have done the exercise now. And none of them, my lord, the parties, but there is a appellant as well as a writ petitioner have been found to be eligible. That minors have annexed in the affidavit.
On the other hand, I have not.
Oh.
It is clarification. Because below, the consideration was taken at in the year 2018.
वो दूसरी बात है दोनों So both of them, Mr. Gogoi, then now both of them are,
No, my lord. In fact, my lord, in page 211, in the minutes, we have stated that none of them has the, my lord, graduation degree. So from 15, my lord, amendment has come in. His promotion was made in 2018. So automatically that amendment will have to be considered. So educational qualification, they don't have both.
Okay.
That's the only.
अभी तो हम इसको खत्म कर देते हैं. When does the amendment come?
It came on, my lord. I'm giving the exact date, my lord. 15/10/2015.
15/10?
2015.
And this selection was made when?
1/2/2018, the promotion was made, by of the appellant. 1/2/2018.
Why was then?
Well, there, my lord, limp of argument was, my lord.
So the first decision by the judge was correct, no?
No, there, my lord, one thing that issue came propped up was that, my lord, that we followed that, my lord, office memorandum. Since, my lord, there is no service rule, this office memorandum of 1999 was followed. But, my lord, after amendment of the rules, my lord, no further OM was issued. Notifying that, my lord, the amendment will have to be, my lord, considered for subsequent promotion. But our argument was that, my lord, it's not a OM, my lord, whereby we have adopted that particular rule. That is a general rule, my lord. It will be applicable for all the department who doesn't have their, my lord, own service rule. Automatically it comes in. So from 2015, my lord, it should be, my lord, graduation. That lordship will find at page 49, that OM. Page 49, the third para. Says there is no service rules for the establishment of the subordinate officers under
The authorities have
this
to
commissioner.
conduct the press selection. Okay.
Well, the press selection is at page 211. 211, well, page, minutes.
Now, both
Both are not eligible, my lord. Yes.
Right. Page 200.
211.
No, we are on a different thing. So this appeal is against the order passed in review.
Yes, ma'am.
No,
This was there as the writ petition.
Against
Because, my lord, review was done, thereafter, my lord, writ petition was reheard, and, my lord,
It is not appeal. This is a
Yes.
writ petition which has been revived.
yes, ma'am.
Mm.
Yes. Press order was passed in the writ petition.
211. Another issue would come. Where you have not notified that. You have not notified the amendment, no?
My
There
lord,
is no OM.
no, my lord, the learned singular said that now we will have to take it forward. So, my lord, we had sought for opinion from all the departments, including the judicial department.
Rule
My lord,
specified in the schedule, to which department it will be applicable.
my lord.
There is schedule
Yes,
to that. In that schedule, your department is not there.
Right.
So therefore, you have issued a notification, but notification nowhere says that you have adopted that. It is your own notification.
my lord, our own
Own
notification. Yes,
notification.
yes.
It is not saying that you have adopted that.
No, no,
Subsequently,
nowhere it is
was
there.
Amended,
15.
amended in 15,
Well.
and you have issued the notification, applied that amendment subsequently without any notification. By
That is a,
reference
that is a fact, my lord. That's why, my lord, in the last para,
Therefore, whether you can apply that or not,
That
is
is,
filed in the IA, therefore you file an IA taking a clarification. Otherwise, this is.
Mr. Gogoi, then this.
then my lord, what lordship has,
Because this writ petition was live that time, no?
Yes.
So therefore, the new rule will not apply to them.
My lord, so far as the Rajkumar's case is concerned, my lord, it is the day when it is considered whatever rule is prevalent for promotion.
That's correct, but rule is.
Rangaya's case, my lord, has been, my lord, now clarified.
Applicable to you.
Yes,
In the schedule, your department is not.
yes, it is for GAD department and all. for
Issue
studies.
notification saying that following the principle, not even saying that we have adopted that rule.
My lord,
So therefore, how can you say that it put out, there is an amendment, or therefore there will be an automatic amendment to our office number?
now, even otherwise also, my lord, whatever has fallen out from this honorable court, that, my lord, so far as the consideration of seniority part is concerned,
That's different, but
that
now
part
you
again,
have
my
said-
lord,
you have said not on seniority, on their qualification of acquiring
Yes.
residence and degree.
lordship.
So that's different.
Because the liberty was now been given to us, my lord.
The, no, the difficulty is this, that it was pending, no?
Lordship.
Writ petition, review, and thereafter.
No, my lord, pursuant to the, my lord, order passed in the, my lord, writ petition, the final order, there are 16.
Now, we will make a distinction now. Where is the original first order?
Yes, sir.
Show us the first order. Let's read it. Where is the first order?
Page 65.
Right. Yes. Right.
Page 70, your lordship will get it.
Yeah, yeah. Yeah. And thereafter,
The page 122, review petition.
page 122.
Relevant, your lordship will get it at 132. Sir, my lord, allowing the review, my lord, at least some time should have been given to us. No, we do not know anything about the stand of the department.
Yeah, allow. Then there
Then, my lord, page 135, read aloud.
Yeah.
And court said you do not know whether the OM is applicable or the rule is applicable. The matter has been assigned to the department.
Mr. Das, there is a reprieve for you now. This has become infructuous.
Because that man,
The judgment has been acted upon.
yes.
Now you have to question the
Challenge it.
press selection process, if at all you are unsuccessful. That's better, you go for that, you question it. This has become infructuous, otherwise you'd have also committed a mistake in deciding the matter. This has taken its effect. Pursuant to the direction passed by this court,
They are right
selection has
here.
been made, which has not been questioned. And both of you have been thrown out, two other persons have been appointed. Kya karenge?
And my lord,
No, you could have argued that the selection had to be considered in terms of 6-6, where the amendment had not come, because it was that time that your case had matured for promotion. But now it is over, the selection has been done, third party interest created, people have been employed, they have been given promotion, that can't be unsettled. So this has become infructuous.
To my inspection, there are one
one post is there.
We will not keep it pending now. He has to challenge. This has been acted upon. Why do we interfere with this?
And my lord, one ground that we have stated in our affidavit as to why the lead appellant was given promotion over the my lord petitioner was that my lord, he approached his honorable court with a prayer that his representation for promotion should be considered. So immediately he was given the promotion, forgetting everything, my lord. That statement is there in the affidavit. That's the ground why he has been, my lord.
That statement goes against your working pattern. No?
Yes, my lord. that-
Working style is difficult.
Right.
I mean, anybody coming with a representation?
Yes,
you allow
following,
that.
Court directed you consider the representation, it doesn't mean that we will
that's the ground. that-
consider my promotion. But
And
what
on
I'm
top
not,
of that, my lord, the lead petitioner is a chowkidar. He is a peon. So peon was,
You want to question that? You question it, it has become infructuous.
you know, let me give the word liberty.
Mr. B. that's.
Madam, since 140.
No, we are not going. This has become infructuous.
Let me say, Madam, because of one observation by the landed singleton, they have aware that we should confirm the qualification become. That was taken in the year 2004, after passing of the order and the petition. Now we don't, now is settled because our promotion was taken for consideration on 1/2/2018.
We have said so. Did we not say so? You're arguing it afresh as if you have something, it's a eureka moment for you. No, we are aware of it. Therefore, we have been hearing all this, right? This is no eureka moment. We understand.
At that time,
Now, the question is that now new rule, we are not on that issue. What is the qualification? Which qualification will apply 1818 or new amendment? No. This judgment which has been challenged has been acted upon. Finished. There was no stay. What do we do?
one post is there.
क्या करेंगे? Go before the authorities, make a representation, be faster than Mr. Das, make a representation. Mr. Gogoi is used to disposing of such
my lord,
representation.
they can challenge it, my lord, in the lead petition, bring for an interim protection.
What do we do with the wrong proposition of law in paragraph 14 of the impugned judgment? Why do we? Pursuant to the judgment impugned, dated 8/8/2024, selection process, a promotional exercise was made by the department, and neither the appellant nor the respondent number 1 succeeded because of the change in the rules requiring basic degree of graduation for promotion to the post of junior assistant, which degree neither the appellant nor the respondent number 1 possessed. Though both the appellant and the respondent number 1 have argued that their cases should have been considered on the basis of the rules prevalent then. But considering the fact that the judgment impugned has been acted upon and other persons have been granted promotion, and the claim of the appellant and the respondent number one has been rejected, this appeal has become infructuous. It would be open for the parties, bracket mein appellant or respondent number one, or respondent number five. Respondent number one, yahan likhe hai, respondent number five. Here it is one, wahan five. One. Respondent number one, to challenge such selection process if so desired.
And regarding the proposition of law, my lord.
Proposition
Your
of law is
lordship,
understood. We are not interfering,
on that
therefore, otherwise
basis-
we would have
on
said this
that
law.
basis only my appointment was set aside by the Learned Single.
Infructuous on that. I agree. They're not here to.
That's all.
Daily list for hearing item 30.
Yes.
May I, Lordship? So the last question, Lordship, Honorable Court, please to direct it to the respondent counsel, Lordship.
Just a minute, Yes.
Lordship, the last question, Honorable Court, is to direct it to the respondent counsel, Lordship, in regard to instruction. Whether 6 other employee. Termination order has dismissed.
Yeah, what is he asking? Who appeared? Mr. DK Sharma is
My
here.
lord, I am afraid.
Have you taken instruction?
My lord, I have tried my level best, but it is not found. My lord, it is 41 years old, my lord. Even I have asked the department to find out, but in the pleadings, I have not found the names of those persons.
You tell us, Mr. Das, you tell us what happened to her.
So, Lordship, and there,
Otherwise, we will not entertain, we will dismiss.
Lordship, the article 14 and 16 is clearly violated, Lordship.
Article
So far,
14 is not.
and the
clear.
Honorable Supreme Court has clearly.
Find out and tell us what happened to the others. Mr. Das, no?
RC Das.
Mr. RC Das, learned advocate, submits that by the next day he shall inform this court about the status of other 6 employees whose services also were terminated, but the termination order was set aside.
Yes.
Whether they were paid or not paid,
Yes, sir.
re-notify April.
For that, if possible, Lordship.
April.
Mas-
2nd April.
Yeah.
Yes, please stop. Daily list for orders item 1.
Yes.
May it please your lordship. My lord, I have review of the order dated 7/4/2025. Passed by the honorable court, my lord.
Yes.
That order you lordship will find at page 8.
We have that order before us. It's
Yes,
a
my
1.5
lord. And so
pages,
far
2-page order.
so far the disputed question is concerned, that is only one. And the Learned Single Judge out of court for the report from the Revenue Department, my lord. And that report indicates that still it has not been verified.
But the
properly.
courts are not, high courts are not supposed to single judge or division bench decide these issues.
Yes, my
Otherwise
lord.
it'll become,
I understand, my lord. And that disputed fact, my lord, is of more serious nature, which cannot be adjudicated in.
That's good. So therefore, there is no merit in this review, according to you. But we withdraw. Or we say that no ground has been made for reviewing the order. Will not call it judgment. It's-
My lord, for that one, my lord, may I take your lordship? The grounds,
No ground. Which ground have you taken? Let's see your ground.
yeah, yes, my lord, your lordship will come to ground number 4. Three and 4, my lord, both at page 3, my lord. It starts at page 3, my lord. For that, the existence of public road. My lord, it is only the question where it
It
is. a
cannot be
public road or
considered
private.
termed as a serious, or shall he have said something else? Serious dispute of fact which requires. No.
Road is carved out of revenue records as they make.
What is so special about this case that we review this order? Correct. Even if that proposition is acceptable, is accepted, then also this is one view. Why get into all this?
My lord, and poor my lord, so far the disputed question of fact is concerned, my lord, that can be gone into in this petition. My lord.
They. Mr. Bhatti, you have the permission. I mean, do we have the permission to dispose it off?
Yes, my lord, your lordship may.
Is that-
But in that case, if your lordship is not going to allow this review petition, in that
We'll
case,
dismiss it lock, stock, barrel summarily.
my lord, in that case, my lord, and maybe this limitation period for filing this civil suit may kindly be excused.
You go and pray.
My lord, because it is the petition
Go
article.
and pray. Do you think in this review jurisdiction we can pass such an order? Supreme Court has come down heavily on high courts whenever such orders have been passed. We only give you the liberty. It's on your advocacy that you will have it allowed before the court. Take that. The review petitioner had been aggrieved with the APDCL erecting electric poles over a portion of land which is claimed by him, one or two, which is claimed by.
There are 4 or 5. My lord.
No, but review petitioner is one, no? Yes. Review petitioner is one. No,
Review petition is only one.
claimed by him. Stop. The learned single judge did not enter into the thickets of facts for the reason that it presented a disputed statement regarding the possession and ownership. First up, similar view was reiterated by the division bench by order dated 7/4/2025, which is sought to be revised by the present petition on the ground that the decision in this case would not have required any collection of evidence or a serious question of possession requiring a full-fledged suit. Stop. In that case, the jurisdiction under Article 226 could have been exercised for redressal of the grievances of the review petitioner / review petitioner. Stop. The trial court, the appellate court, it has been contended, took a shortcut approach of endorsing the view of the learned single judge without entering into the arguments urged on behalf of the review petition. Whatever may be the case, on a consideration of the fact that both sides claim the land to be theirs.
No, my lord, they are claiming that it is a public road.
We find justification in the order of the learned single judge as also the division bench that if at all the rights of the review petitioner is to be vindicated, the forum would be civil courts and not any proceeding under Article 226 of the Constitution. Stop. Finding no merit in the review petition, the same is dismissed.
But
However, the petitioner, one is petitioners dismissed. However, the petitioners, review petitioners shall have the liberty to approach the appropriate court forum for vindication of their rights.
Deeply appreciated.
Good enough. We have heard Mr. O.P. Bhatti. O.P. Bhatti, no? O.P. Bhatti, Mr. Bhatti had appeared in a matter which apparently did not have merit, but he argued very well.
plastic, plastic.
Plastic, yes. I heard Mr. So-and-so and so-and-so. Right, next.
Item number 2,
Deeply appreciated.
Where is Mr. Notice, issued no respondent, what is the office now? Awaiting the service of notice on the respondents, this review petition is adjourned to give a date after 4 weeks. Nobody is here. Why?
23rd March. Still is not here.
Subject to availability of
Okay.